My friends, I just pressed the let's go live button, which means we've got to wait for the stream to fire up all across the fruited plain of the internet. Before we go ahead and get started, it is a beautiful Friday. I hope you had an incredible week. We are making it all the way through a full week. We had trial all week and we are about done, but we're not done yet. We got to make sure the tubes are working. Looks like they're working over there. Let's check over here. It looks like they're working over here. That's tremendous. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about the Supreme Court, Colorado ballot removal situation happening with Donald Trump. We know, because we've been covering it here for some time, that there are 4 Democrats in Colorado who are judges on the Supreme Court there, and they decided that Donald Trump is an insurrectionist. And not only that, that the insurrection clause under the 14th Amendment also applies to him. Donald Trump, of course, appealed that because they said he should not be on the ballot. To save democracy, they have to remove from the people the right to vote from Donald Trump, up for Donald Trump from them. And so, of course, Donald Trump is appealing this to the Supreme Court of the United States, and bum, that's where we are today. Trump and his defense team, they submitted a Colorado brief to the Supreme Court for the petitioner, them, and we're going to go through it, see what's inside. It has a lot of the same arguments we've seen elsewhere here because this is a ridiculous case and there are all sorts of appeals about the 14th Amendment and the insurrection clause and the office of the presidency and so on. But we're going to talk about it. Then we're going to see we got Crazy Eyes Griswold. You remember Jenna? You can see just, gosh, look at those eyeballs. Oh, man. So she was speaking, I think, with Anderson Cooper and was explaining why this is so necessary, why Trump is such an insurrectionist. And you can see we're going to hear from her and just see what she says about all that on the show with Anderson Cooper when she was talking to him on CNN. So we'll see what Crazy Eye says. So we'll hear from her. Then we're going to hear what Trump said because he was responding to some of this. He showed up over on the Hannity show, and we'll see what he said about this. This is a big one because this was a briefing deadline. Yesterday, all of the briefs came in, amicus briefs from Edwin Meese. Bill Barr, by the way, we're not going to talk about this today, but Bill Barr filed a brief in support of Trump, saying Trump has to be on the ballot because the 14th doesn't apply to the president. So a lot of things are happening, a lot of stuff going in to the Supreme Court right now. We're going to see what Trump said about it. Then we're going to turn our attention over to New York, where in the Southern District, Alina Habba, where she filed a letter motion over to Judge Kaplan in the E. Jean Carroll case. You know, Miss Bergdorf, who claimed she got Bergdorf over 20 years ago in the dressing room at Bergdorf's. And they admit in her testimony, she admitted that she deleted evidence. Oh, that the defense, Donald Trump and his people wanted. Alina Habba moved for a mistrial in the trial. And Judge Kaplan said, no, sit down, shut your mouth, Alina. I don't want to hear from you anymore. And so she submitted a letter. She said, all right, well, I'm renewing this. You cut me off in court. I have to make a record. And so, boom, she did. We're going to go through all of that as well. And then in our third segment, we got to talk about Fani Willis and Nathan Wade. This is getting a little bit even spicier than we had thought. And so we're going to go through some of this stuff. Now, what we have learned is that Nathan Wade bought Fani Willis's plane tickets and cruise tickets. And in fact, we've actually got the motion that shows those and shows that they got cruise line tickets and so on coming right out of Nathan Wade's bank account. So Nathan Wade, of course, the special prosecutor who's been appointed, new meaning to that word, by Fani Willis right here. So these two little lovebirds on cruises. And we'll go through it because Fani was super upset. We know Jocelyn Wade seems like a very nice woman, very loyal, was married to this dude for 20-something years, raising the kids and everything. And then he just said, I'm out of here. He sees some bigger Fani and he goes over there and he's like, I love you, baby. Give me $1 million. I'll take you on the cruise. So something happens. The whole thing gets deviated. Now they're going through a divorce, Jocelyn and Nathan, and Fani sent in this emergency motion saying, I shouldn't even be subpoenaed because I'm the biggest Fani in Fulton County. Well, what? She says she's the DA, and she's blaming Jocelyn for trying to interfere with her prosecution of Trump. She's actually blaming the divorcee whose home that Fani wrecked, blaming her, saying she's trying to interfere with the entire investigation. I guess she's an insurrectionist is where this is going. And then we've got this amazing clip. Shout out to Julie Kelly on X. She clipped this one. We're going to go watch it on her page. But this is another YouTuber. Shout out to Unwind with Tasha K. Okay, she's also got a big YouTube channel, 1 million+ subs over there. And she was dropping some fire about this whole Fani Wade situation. And we're going to hear what she had to say about it. You can see she's fired up too. It was absolutely outstanding. So we'll listen to that. So a lot of good stuff coming up, my friends. And we are grateful that you are here and with us today. And as you can see, a lot of stuff to get into after the show is over. We are going to go to watchingthewatchers.locals.com, where we're going to hang out for our after party. We'd love it if you joined us over there because we have an amazing community. We do streams in the morning. We already had a great stream this morning talking about all sorts of stuff. And today was fun. We talked about recovery and, wellness and some health stuff. It was an interesting conversation. And so watchingthewatchers.locals.com will also be here tomorrow for our Saturday stream, and we'll look forward to seeing you there. We've also got our website, robertgovea.com, where if you want to get any of the PDFs that we're about to go through, that's where you can access them, robertgovea.com. And of course, before we get into any of the meat and potatoes on the day, we want to say thank you to our friends at Private Internet Access, because it is a dangerous world out there on the internets, my friends, and you want to be secure, and you can do that with PIA VPN. It's important to stay protected on the internet, my friends, and Private Internet Access will help you do that. Private Internet Access is a VPN service that creates an encrypted tunnel for you when you browse the web so that people on the same network as you can't snoop in and see what you're doing. And that's awesome. But what I also love about a VPN is that it allows you to change your IP address to one of over 90 countries around the world. This lets you bypass geographic restrictions on certain websites like Netflix that will often limit movies or TV shows like one of my favorites, The Office, and they do that based on your region, meaning that when you change your region, you get access to additional content you might not otherwise see. PIA also gets you around website geo restrictions. For example, Canadians now can't access Facebook News and Google News due to the controversial BC18 bill, but with PIA, they can. And what I like most about Private Internet Access is that they are the world's most transparent VPN provider. With over 30 million downloads and a no logs policy means they never record or store user data. All this has been verified by a third-party audit from Deloitte and successfully defended in court in litigation. And now, Private Internet Access allows you to protect all your devices with just one subscription, so you can protect your whole household in one go. Super simple. So let's get you a VPN from Private Internet Access. Go to www.piavpn.com/Robert, and you'll get 83% off and 4 months free when you sign up for a 2-year plan. Be sure to use my link for a major discount on this initial offer, and my friends, will see you at piavpn.com/Robert. All right, my friends. So thanks for checking out our sponsors. Link is down in the description below, and we'll see you over there. All right, now let's get right into the meat and potatoes on the day, starting with the Supreme Court. Donald Trump submits his brief to the Supreme Court of these United States. He is petitioning the court to undo what Colorado has done, which is ordered him removed from the ballots pending further review from SCOTUS. We're going to go through the full petition. There has been a lot of activity on this case because everybody is skidding in their briefs, amicus briefs from state secretaries of states. Attorneys generals are submitting theirs. We've got House of Representatives that have submitted theirs. Senators are sending theirs in. We've read from Edwin Meese, former AG for Ronald Reagan, sent his in, and even Bill Barr sent his one in, supporting Donald Trump, saying Trump needs to remain on the ballot. So Supreme Court is going to be getting into this very soon, but this is Donald Trump's brief himself. We're going to hear what Crazy Eyes Griswold over from Colorado, the Secretary of State over there, what she has to say about this in response. And then in this segment, we'll wrap it up with Donald Trump's reaction, saying, how is the court going to rule? He'll weigh in. So first, let's go right over to the brief itself and dig into it. In the Supreme Court of the United States, the case is Donald Trump as the petitioner. He is against Norma Anderson and the respondents. These are the litigants from Colorado who filed their private claim to remove Trump, saying he was guilty of an insurrection and he was disqualified under the 14th. So writing for Trump, you see Harmeet Dillon's law group, shout out to her, and the rest of the co-counsel all submitting their brief. They're asking the Supreme Court, they're saying, all right, SCOTUS, this is a pretty important situation here. We have an election coming up any minute. The Supreme Court of Colorado, they held that Trump is disqualified from holding the office of the presidency because, one, he engaged in insurrection, and that he did so after taking an oath as an officer, and that oath was to support the Constitution. Now, the state Supreme Court, 4 Democrats, ruled that the Colorado Secretary of State, Crazy Eyes Griswold, should not list Trump's name on the 2024 ballot. And then she comes out and lectures us, saying this is all done in the sake of democracy. So the question here for you, SCOTUS, is very simple. Did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 primary presidential ballot? Yes or no? Now, we know all the parties to the proceedings, Crazy Eyes Griswold, we got Trump, we got all the Anderson petitioners, the litigants. And we'll see that a lot of these arguments are the same things we've already discussed, but this is from the perspective of Donald Trump. And this is a historic case. I really do think that if SCOTUS, for whatever reason, allows the states individually, allows Colorado to just unilaterally on their own say the 14th Amendment is self-executing, boot him off the ballot, this country's in for a very, very rocky election and beyond, because that is going to allow this domino effect that's already in motion to continue to occur. And states like Arizona, where I'm at, will absolutely be next. We'll see lawsuits filed, and they'll say, well, Colorado did it, and they're like right over there. So why don't you do it too? And Arizona's a swing state. Maybe Colorado is going to go blue anyways. I'm not so sure about that. But you can see what's going to happen. Eventually, one state is going to matter, and it's going to cause a fissure and a fracture that is literally disenfranchising millions of voters if it's allowed to stand. So this is what Donald Trump says. All right, SCOTUS. On December 19th, the Colorado Supreme Court ordered President Donald Trump, the leading Republican candidate for president, removed from the presidential ballot based on a dubious interpretation of the 14th. And now this domino effect is underway. 30 states are now trying to remove Trump from the primary in the general election based on similar rationales. And yet, it is, quote, fundamental principle of our democracy embodied in the Constitution that, quote, the people should choose whom they please to govern them. Saying this court, SCOTUS, should put a swift and decisive end to these ballot disqualification efforts. These threaten to disenfranchise tens of millions of Americans, and which promises to unleash chaos and bedlam if other state courts and other state officials follow Colorado's lead and exclude the likely Republican presidential nominee for and from their ballots. Saying the court should reverse the Colorado decision. Why? Well, because Trump is not even subject to Section 3, as Trump is not an officer. The president is not an officer of the United States. And even if Trump were subject to Section 3, even if you say it did say the president fit under there, like a sub-bullet point, well, he didn't engage in anything that would ever qualify as an insurrection. And so the court should reverse on these grounds and end these unconstitutional disqualification efforts once and for all. Writing, there are additional grounds for reversing the Colorado Supreme Court. Now, the state courts should have regarded congressional enforcement legislation as the exclusive means of enforcing Section 3. In other words, Congress should have done something. We hear this back and forth about whether Section 3 is self-executing or not. In other words, does Congress have to do something? Does there need to be some legislation in order to enact that? Or can Crazy Eyes Griswold and Shenna Bellows just say, well, you know, they were on a Zoom call with the rest of their Avengers, the Secretary Avenger team, and they just decide to, you know, kind of copy each other's homework? Or does Congress have to do something, you know, like impeach and convict someone, or indict and convict someone somewhere else? So in addition, Section 3 cannot be used to deny Trump or anyone else access to the ballot. Why? As Section 3 prohibits individuals only from holding office, not from seeking or winning election to office. That's a pretty interesting little nuance there. Well, Trump's not holding office right now. He's just running. And maybe if he wins before he's seated, that's the appropriate time to challenge this. And then Congress could overcome that removal by the 2/3 vote pursuant to the operation of the statute. So we'll get into that. Now, finally, they say Colorado Supreme Court ruling, it violates the electors clause as well, because nothing in Colorado's election code allows the state judiciary to order the secretary to remove the candidate from the ballot. Now, the court has jurisdiction. We know who the parties are. Trump and everyone else. Saying here, Your Honors, at the Supreme Court, over the last few months, more than 60 lawsuits funded by who knows who, or administrative challenges have been filed in an effort to keep Trump from appearing on the ballots. Now, the theory behind these lawsuits is that Trump is disqualified under the 14th. Why? January 6th insurrection. Now, many courts have rejected these claims for various reasons until Colorado showed up on December 19th and said, "Merry Christmas, America!" And they ordered Colorado Secretary Griswold, Crazy Eyes, to exclude Trump from the ballot. And she is rabidly anti-Trump. If you follow her on X, it's wild. Every day she's got a new anti-Trump post. And she's going to be the person who's running the elections as the Secretary of State. So why would she be trusted to do anything without bias if she's clearly rabidly anti-Trump? Anyways. So the respondents in this case include 6 individuals. These are the Anderson litigants. Trump is appealing this. They responded. They sued Colorado and Griswold. And we saw this same pattern in 2020. So I am, ringing the alarm bells just like we did in 2020. This is what happened, okay? Friendly groups sued friendly secretaries of states, and they colluded under COVID to change the rules. They went to friendly judges. Nobody knew what was going on because we were all like, are we going to die tomorrow or what? But this is what they were. Oh, COVID's changing. Oh, COVID. So signature, collection, ballot drop off, waive this, waive that. It was Bedlam. And they did that because friendlies sued friendlies like they were playing like, oh, no, don't sue us. Oh, no. And then they would just agree to each other and go into these courts, and the courts would rubber stamp it. It would rig the whole election. We covered, I don't know how many videos we did here. They're all there. So the Anderson litigants, they sued under Colorado revised statutes. And then they said, Colorado's like, well, you're right. Wow, thanks for bringing it to my attention, says Griswold. You're right, I do have an obligation. And so I do need to do something about this. Now, nothing in Colorado's election code actually does require her to do this. She says, well, thank you for suing me. I guess I have a constitutional duty to analyze Trump's insurrection. And lo and behold, she found insurrection. Just happened to coincide with her political biases, but yeah, I'm sure she did her due diligence. So now she says, I have no choice. And then we have this litigation that happens. Trump is ultimately removed. But Trump's people are saying she had no basis for doing this. There's nothing that requires her to do this. She just shoved herself into this process because she's got TDS. Instead, the Colorado statutes actually requires the presidential primary candidate to submit a notice of intent. That form, we did this, and we got the form right from her website. And all it says is this right here. This is the form. You can see this is what Trump's people filled out. Here are the qualifications for office. You must check each box to confirm that you meet all the qualifications. Trump, 35 years of age, got that, no problem. Resident of the United States for 14 years, bingo, got that one. Natural born citizen, bingo, got that one. Now that's it. The statement of intent form also requires candidates to sign an affirmation that they meet all the qualifications as prescribed by law. That's it. Here it is. I intend to run for the office stated above, and I solemnly affirm that I meet all qualifications for the office prescribed by law. That's it. That's your job. So Trump says, beautiful, got that right there. Donald Trump signs that, boom, and then that's the end of the question. That's the end of the conversation, says Trump's people. Now, a signature line appears below that, along with an unfilled notarial certificate. Now, Colorado law, it imposes no duty on the secretary to actually verify or to second guess any of this, or to exclude candidates from the ballot if the secretary believes or disagrees with that. You don't get to decide. Well, So Anderson litigants nonetheless insist that she does have a mandatory duty, the people who sued. You can't just stand by. Even though there's nothing on your form that says insurrection, there's no insurrection box. I promise I didn't commit an insurrection as governed by fake insurrection committees governed by Liz Cheney and Benny Thompson. There's not that form on here. Okay, so Trump didn't have to click anything. So as we continue, they say here the 14th Amendment is not where they derive this. They also claim that any decision to put Trump on the ballot would violate the Constitution. It would be a breach of your duty, right? They actually were suing her like, listen, Jenna, if you don't actually throw him off, you're the bad person. You're a co-conspirator, essentially. So they sued. They sued her and said, well, now she's just sitting at her office. She's like, oh, this is a great lawsuit. Throw Trump off the ballot? Perfect. Great. What do I have to do to fake like I'm defending this? So then the Anderson litigants, they sued. They filed it September 6, 2023. The district court did not hold a hearing within 5 days. So procedurally, they goofed. Law says, well, if there's an election litigation situation, you got to have a hearing quick. Timelines are compressed. Law says no later than 5 days after the challenge is filed, the district court shall hear the challenge and assess the validities. Not may, not like a suggestion. It's like shall be done. So schedule it now, go. That's the law. Instead, the district court held a status conference on September 18th after the statutory deadline, and the 5-day hearing began 54 days after the fact, not 5 days after the challenge was filed. So they're way late. Now, the district court denied a bunch of motions to dismiss this case. They also denied Trump basic discovery tools, like the opportunity to depose expert witnesses, like the opportunity to subpoena and compel the production of documents, like the opportunity to get timely disclosure so they could actually, read it. And the district court's improvised yet still compressed time frame gave Trump only 10 days to identify his rebuttal witnesses and 18 days to identify his rebuttal experts. Then we had this fake 5-day scam hearing that we listened to. The court did not issue findings and facts within 48 hours, even though the law says that. She waited. Instead, the district court held closing arguments 12 days after the fact, and then they issued findings and other conclusions of law. Now, their findings of fact rely heavily on the final report by the illegally constituted January 6th Select Committee, and that's by their own standards, okay? H.R. 503 was the governing document, and it is not complied with Liz Cheney. There were supposed to be 5 Republicans on there. There were not. There were 2 by their own document, and they are illegal pursuant to their own governing records. So the district court also relied on testimony from Peter Simi. But backing up, by the way, the J6 stuff was all hearsay. It was all a legislative book report that was not subject to really any cross-examination at all. At all. There wasn't any cross-examination. There was not even any opposing witnesses presented. There was not even an opposing narrative. It was literally a big, long book report, like with PowerPoints, reading from their slides. It was ridiculous. And a lot of it's fake, by the way. Clavicle Girl, for example, is just one example of the fake testimony that's not even true, which would have come out if there was cross-examination and due process. But there wasn't. So they admitted it anyway. She's like, close enough. Liz Cheney's a congressperson. Not anymore because she lost big time. Pff, loser. So the district court also relied on this guy, Peter Simi. He's a sociology professor, and now he's, I guess, responsible for American elections. Now, he said Donald Trump speaks like far-right political extremists. And so they listened to him because he has a history with political extremists. So the district court wrote, Trump's encouragement and promotion and the fight, it wasn't metaphorical. He was referring to literal violence. He was calling people to violence. Now, this guy, this sociology professor, relied exclusively on public speeches. He conducted no research interviews. He didn't do any field work. He disclaimed any opinion on Trump's state of mind. He has no idea. But the district court still used this bizarre testimony to support its factual finding. This guy's like, well, I watched a lot of Trump videos on the internet. Okay. So what are you doing here? To talk about your opinion of Trump? Thanks. Judge is like, well, this is brilliant testimony. Love those videos. Great YouTube channels. So for its conclusions of law, the district court held that the Colorado Election Code does not allow the Secretary of State to assess the candidate's eligibility. The lower level court, Judge Sarah Wallace, was even not crazy enough to do this, despite her hair. But it nonetheless held that Section 11 of this does give courts the authority because it requires district courts to hear the challenges. So she actually did hear the case. We heard that. Now, the district court did go on to hold that Trump engaged in an insurrection. We're familiar with that. But they said that it doesn't apply to the presidency. It said the presidency is not an office for the purposes of this. Okay, so that's Sarah Wallace. Got it. Then it went up to the state Supreme Court. So both Anderson and Trump sought review at the next level. Why? Trump said, first of all, yes, I know it doesn't apply to me under the 14th Amendment. But secondly, I'm also not somebody who engaged in insurrection in the first place, because she found that there was an insurrection, but it didn't apply to him. He's saying, no. First of all, it doesn't apply to me, but there wasn't an insurrection, so you were wrong there. So they both said she was wrong, but for different reasons. Now, the Colorado Supreme Court ultimately found as they found. And so we'll fast forward through some of this. They say, having concluded that the Anderson litigants could proceed, the state Supreme Court then considered the merits. So they bypassed all of the procedural stuff. Well, that's delayed, whatever. They said, no. Trump had plenty of due process. The fact that he couldn't subpoena evidence or that he didn't have time to actually read documents or things like that doesn't matter. He got enough due process. The fact that it was hearsay evidence from Liz Cheney, no, it's okay. They don't care. So they ultimately reversed, and they found that it does apply to Trump. And so now let's see their argument. A lot of procedural history there that I think maybe could have been condensed a bit, but here we are. They say the court should reverse now because President Trump is not subject to Section 3. The president is not an officer of the United States, as that term is used in the Constitution, lowercase o. President Trump also never swore an oath before he became president that could either trigger that. And number two, the court should also reverse because Trump did not engage in an insurrection. The Colorado Supreme Court tried to impute the conduct of others onto Trump, but the litigants needed to show that Trump's own conduct, his own conduct, was an insurrection on its own. And they can't make a showing because Trump never participated in any of the conduct. In fact, the opposite is true. Trump sat around calling for peace and patriotism, telling him to go in peace. But the court should follow the rationale, they say, of the district court's dissent and allow judicial and judiciary enforcement only through congressional implementation of legislation like a different section of the U.S. Code. Says Congress should be the people who decide, not the lower level court. Saying the Colorado Supreme Court also violates this Supreme Court case called Thornton. That case prohibits states from prescribing their own qualifications for the presidency. You don't get to decide that this person's eligible or not because we have a federal constitution that encompasses the nation. The Constitution requires, they say, that the president qualify that under Section 3 only during the time that he holds the office. But Colorado Supreme Court is demanding that Trump is disqualified at the time the primary and the general elections occur, which is during the run. And 5, they say the Colorado Supreme Court ruling also violates the Electors Clause and that the judiciary should not be allowed to remove them. So let's get into this analysis. First, that Trump is not an officer of these United States. They say, all right, Supreme Court. Section 3 says this. It only applies to those who have previously taken an oath as a member of Congress or as an officer, lowercase, of the United States, or as a member of any state legislature, or as an executive of any state, to support the Constitution of these United States. Now, it's undisputed that Trump never took an oath as a member of Congress. Okay, so that one's gone. So member of Congress, so that's deleted, get rid of that. He never took an oath as a member as a state legislator. Okay, get rid of that one. He also was not a state executive or a judicial officer, so no state executive. So that's gone too. He was not a member of any state. Okay, so that's gone. So it would have to be just this one, an officer of the United States. That's it. Now, the Constitution's text and structure makes clear The president is not an officer of the United States. Why? The phrase officer of the United States appears in 3 constitutional provisions outside of the 14th. The Appointments Clause says that the president shall appoint ambassadors and all other officers. Ambassadors, public ministers, consuls, justices, and all other officers. Now, the Commissions Clause also says commission all the officers of the United States. Commission all. See that? Meaning that everything else. The president does not and cannot appoint or commission himself, obviously, and he cannot qualify as an officer of the United States when the Constitution draws a clear distinction between officers of the United States and the president who appoints and commissions them. Similarly, the Impeachment Clause. It also shows the president is not an officer of the United States. It says, look at they distinguish this. The president, the vice president, and all civil officers of the United States shall be removed on impeachment, high crimes, and misdemeanors. See how that's separated out? That's not what we saw up here. They could have put and inserted right into this president and vice president, but they did not do that. In fact, they removed them. Now, there is no need to separately list the president and the vice president as targets of impeachment if they are also civil officers. If this is the same as this, then why do we need these things? You don't, because they're not the same. That's why they included it there and not in the other one. Now, they say this is explained by Justice Story. The enumeration of the president and the vice president as impeachable officers was indispensable. The Impeachment Clause does not even affect to consider them officers of the United States. The other clauses of the Constitution would seem to favor the same result, particularly the clause respecting the appointment of officers of the United States by the executive, the president, who is to commission all the officers of the United States. Now, the precedent of this course confirms this as well. We've got some other cases, in 2010, courts had some more case law. This court interpreted the phrase officers of the United States that extends to those appointed by the president, not the president himself. Now then, there's also the fact that Section 3 applies only to those who took an oath to support the Constitution. That's the oath required by Article 6, saying senators and representatives before mentioned and the members of the several state legislatures shall be bound by the oath or affirmation to support the Constitution. But that's not what the president does. The president promises to preserve, protect, and defend the Constitution, and the word support is nowhere to be found in there. So the Colorado Supreme Court didn't explain that. Well, how do you explain that oath versus the promise? And it entirely ignored Trump's argument, didn't even explain it, just skipped over that. Well, that fact is very inconvenient for us, so we don't want to talk about that. They said that the normal and ordinary usage of the term officer also includes the president. Well, it's like close enough. Same thing that they're doing with E. Jean Carroll. Yes, we have the R word and the assault word, but we're just going to bundle it all up into the R word because we lost on the R word. So that is simply false. They say every time this phrase appears in the Appointments Clause, the Commissions Clause, the Impeachment Clause, 3 different locations there, they say it excludes the president and refers only to the appointed and the commissioned officers rather than the elected officials. No president in there in any of them. Now, the Colorado Supreme Court noted that Federalist number 69, it describes the president as an officer elected by the people, and that Andrew Johnson once described himself as the chief executive officer of the United States. But none of that has any bearing on whether the president is actually an officer of the United States, as the phrase is used in the Constitution. The Colorado Supreme Court also cited a draft law review article, not even published apparently, to support its claim that Section 3's drafters and their contemporaries did understood him as an officer, but that article cites nothing and purports to the Constitution's use of the phrase. The Colorado Supreme Court also noted that the president is an officer in the ordinary meaning, and they claimed that Trump conceded that point in the colloquial sense, but the Constitution makes clear that one can be a lowercase officer without being an officer of the United States, by the way. Article 1 requires the House and the Senate to choose their officers, but these legislative officers are not officers of the United States. So, in other words, the word officer is thrown around like even more loosely in other places in the Constitution. So the same goes for the Colorado Supreme Court. They say that the presidency qualifies as an office. No, they say, well, okay, it's obviously like an office, like it's a building that has offices in it. But whether the phrase office under the United States includes the presidency is far from clear in the Constitution. Occupying an office, even an office under the United States, does not make one an officer of the United States, as that term is used in the Constitution. The Constitution refers to officers and offices, including officers in the House and Senate, and offices of the president and the vice president. But none of the individuals who hold those offices are encompassed in the phrase officers of the United States. That's why they articulate it the way they do. Now, the state Supreme Court also invoked two other statements that they say are not relevant. First, Attorney General Stanberry, he observed the phrase officers in these United States. And the second statement was from something else that they don't say is pertinent. And so let's fast forward through some of this until we get some more analysis. They say the Colorado also points out that Section 3 prohibits disqualified individuals from serving in the Electoral College, but it does not disqualify former electors who engage in insurrection. They say, so there is, once again, no basis for insisting on correspondence between the listed categories of who is disqualified, because everyone could essentially be under the office of the United States, right? If like everything could just, if it's just a broad category that's meaningless, then why didn't they just say office of the United States? Just put them all in there. And they say canons of constructions also support our interpretation here. Now, when Section 3 lists the officials and the positions, it does not mention the president. It does not mention the presidency at any point. It also lists the covered individuals in descending order, right? So it's most powerful to least. The highest federal officials and going down. Then it has a catch-all phrase, any office, civil, military, and so on. And so if we're accepting Colorado's assertion that that includes the presidency, well, then one must include and conclude that the drafters decided to bury the most visible and prominent national office catch-all in this phrase, any office. Just, presidency too. This reading defies common sense. Nobody thought that's what it meant when they drafted the 14th. In Section 2, they carry on. Trump's defense at the Supreme Court, they say, all right, SCOTUS, the court should also reverse because nothing that Trump ever did in 2020 in response to the election even remotely qualifies as an insurrection. No prosecutor, not even deranged thug Jack Smith, has attempted to charge President Trump with insurrection. There is a U.S. statute for this, 28 U.S. Code 2383. It's right there. Charge someone, Jack. In the 3 years, not a single person, despite the relentless and ongoing investigations of President Trump. And for one good reason. Why? President Trump's words that day specifically called for peaceful and patriotic protest and respect for the law and for order. Saying in his speech at the Ellipse, President Trump told the crowd to peacefully and patriotically make your voices heard. Trump said, I encourage support for our Capitol Police and our law enforcement. And on the evening of January 5th, President Trump even instructed the Secretary of Defense, who had authority to deploy the National Guard, he said, do what's required to protect the American people. What a great president. It's going to be nice to have him back, isn't it? Now, Trump never told his supporters to enter the Capitol, and he did not lead, direct, or encourage any of these unlawful acts that occurred. Now, either in his speech at the Ellipse or in his statements. Now, Trump also sent tweets throughout the day saying, remain peaceful, stay peaceful. He told the crowd to go home now. But the Colorado Supreme Court instead faulted Trump for, in its view, failing to respond with the alacrity when he learned that it had been breached. They wanted Trump, I guess, to just start live streaming, like pulling his hair out, lighting things on fire. I'm so nervous. crying or whatever. Like, I don't know what they wanted. But they did the same thing with George Bush. Remember, they were criticizing him. They're like, well, he sat there in front of those kindergartners for like 5 minutes. What an idiot. He wanted it to happen. You're like, can you relax for 2 seconds? Like, it's Congress. That's their prerogative, by the way. That's their jurisdiction. What's Trump going to do? Send in the National Guard? And he tried to do that on January 5th. Mayor Bowser sent a letter back to him saying, we don't want your support. And they called him somebody who's going to try to take over the Capitol for wanting to bring troops in to secure the Capitol, right? So he's damned if he does, damned if he doesn't. So Trump didn't respond like a hysterical lunatic like Liz Cheney was supposed to. A failure to act, even if that's true, doesn't constitute engagement in an insurrection. Engage carries the idea of active rather than passive conduct, voluntary action. Calling for peace, calling for patriotism, respect for the law and order, and directing the Secretary of Defense to do what needs to be done is not leading an insurrection. But Colorado held the events were an insurrection. Why? Because a large group of people forcibly entered the Capitol, which was orchestrated by Ray Epps, who got probation, by the way. He showed up on the FBI's most wanted list, but I guess not that wanted. The mob was armed with a wide array of weapons, which were what? Flags with pointy ends on them. There were like 2 guns there, if that. The mob stole objects from the Capitol premises. Wow. Yeah, like the podium. Yeah. Which I think was going to be control of the country. And they repeatedly and violently assaulted police officers. Yes, so did Ray Epps, shoving signs into cups. But Trump did not engage in any of those activities. No. And none of the president's actions from Trump were anywhere close to an insurrection. Raising concerns about the integrity about elections is the job of the executive branch. He's supposed to look into fraud and irregularity. Giving a passionate speech that says fight like hell, metaphorically speaking, is not an insurrection either. And by the way, the 14th Amendment in Section 3 is not a vicarious liability crime, meaning that I'm not guilty for someone else's conduct. There's no legal basis for imputing the conduct of others to Trump. The Anderson litigants instead must show that Trump's own conduct, and not the conduct of anyone else, is actually an insurrection. But no, they insist that Trump's speech, his words, and his statements leading up to the events constitutes acts of insurrection. Because this sociology professor, called Professor Simi, he said Trump was speaking in coded words. And he can interpret them because he can talk to extremists. Both the district court and the state Supreme Court relied heavily on his coded language testimony. It's like the MAGA whisperer. Neat. But this court should not allow a candidate's eligibility for the presidency to be determined by a coded messages sociology professor from some school. This court cannot tolerate a regime that allows the entire state's electoral governance to be dictated by Sociology 101. Now, finally, President Trump's speech at the Ellipse and his post-election tweets do not remotely constitute incitement under Brandenburg versus Ohio. First, Trump's statements cannot be punished under Brandenburg unless they were directed at inciting or producing lawless imminent action, which they weren't, and that they were likely to incite and produce that action. Now, the Brandenburg standard does not turn on whether violence actually occurs. It turns on whether it was intended and likely to incite the violence. Now, and the constitutional status of Trump's statements would be no different if he had given the same speech and his supporters remained entirely peaceful as he urged. This court would never tolerate criminal prosecution of his speaker who told his audience to fight like hell and take our country back, because that is political discourse. It's very common. And because Trump did not incite violence, under Brandenburg, it's free speech, and he did not engage in insurrection. This is amazing. Nor can Professor Simi's code-breaking abilities. He's like a cryptographer, you know. Probably has spreadsheets of coded language from MAGA. What does 1776 mean, Professor? Are we under attack? He's going to transform core political speech into proscribable speech. You're not allowed to say that, or else you're a right-winger. Now, the words uttered by President Trump on January 6th would be regarded as entirely benign if they'd come from anyone else who's not Trump. But this guy, goofball, he said that the courts, they had a Trump-specific version of the First Amendment. because he's so dangerous. He says Trump speaks in coded language. But intent becomes relevant under the First Amendment. And they just imputed to him nefarious motives. An inquiry to the speaker's intent can never be transformed from a constitutionally protected speech into unprotected speech just because a sociology professor says so. They say, look, SCOTUS, as we wrap this up, let's be clear. Section 3 should only be enforced by Congress and whatever they choose. Enforcement should not go to state officials like Crazy Eyes Griswold. Congress enacted enforcement that required prosecutors to do certain things, and the Insurrection Act also provides that if you're convicted of engaging in insurrection, then that matters. But Congress has also since repealed the quo warranto provisions from the 1870 Enforcement Acts, but the insurrection clause remains. So they say we should follow this pattern. A presidential candidate's eligibility for office should not be resolved by having state trial courts evaluate opinion testimony from a sociology professor and copy factual findings from a hearsay-filled and partisan congressional committee report, and then courts demand that they defer to their facts. It's all just fake. I mean, great paragraph there. So they say the court should reverse. Section 3 can't be used to throw Trump out of here. By the way, it's only from holding office, not running for office. So if he wins, then you can sue us. But it says no person shall be a senator or representative. And even if they say president, or look, the elector of president. Now, there's also good argument from Edwin Meese that the safeguard, like the reason why we don't have presidency in here, is because electors also provide a safeguard on this, because the electors are essentially prohibited. So it does not prevent anyone from running for office or from being elected to office, but because Congress can remove that, right? So even if they say it did apply, Trump could run, win, and then Congress could remove it. Congress may, by a vote of 2/3 of each house, remove the disability. Congress has done so on many occasions. They give us a long list of these. Disabilities are removed. The men who were voted filled their several localities, and they filled important offices. So the existence of the disability removal provisions shows that it's Congress that ultimately decides whether someone can be seated or not. Now, the Colorado Supreme Court did not go so far as to hold that Section 3 bans Trump from appearing on the ballot, although there was some language in its opinion that gestures towards that idea. Instead, it held that only qualified candidates can appear. And so they basically created a new qualification. Now, this prior case says that they're powerless. They can't do that. They created a new qualification out of thin air. And so their case violates that by prescribing a new qualification for the presidency. It requires that a president be qualified under Section 3, not only on the dates that he holds office, but on the dates that he's running for office. The Constitution doesn't say that at all. Interesting argument. So they created something new. It says holding, not running. And that's a new requirement. Supreme Court precedent says can't do that. That's a nice technicality there. Now, this is no different from a state enforcing another residency requirement. Just pick any other requirement. No person shall be elected. When elected, be an inhabitant of a state. They say there were other provisions as well. So a lot more meat on that section. As you see here, Colorado Supreme Court also violated the electors clause, is what they say. The Colorado state legislature allows the judiciary to intervene in ballot disputes only when charged with a duty. And this bars Trump from holding the office. So the Colorado Supreme Court, instead, they tried to concoct a wrongful act. They made it up. They claimed Secretary Griswold would violate the law, a provision of the state election law, but she's not going to violate anything. She just took that on her own accord. So the Anderson litigants were wrong. Trump didn't forfeit any of his claims here. The courts precluded him from making them. Colorado is what its statutes say, and so these cannot be flouted. And so respectfully, they say the judgment of the Colorado Supreme Court should be reversed. All right. So Interesting filing here, 59-pager from Donald Trump, landing up at the Supreme Court. A lot of technical stuff in there, and I think we spent a lot of time on the procedural history, but really hitting the meat and potatoes of a lot of the same stuff we've heard before. And we'll see if there's anything that the Supreme Court likes and latches onto there. As I'm reading that, I'm thinking, okay, are they writing for any particular judges? What judge is going to latch onto what arguments? And how are they going to resolve this? Are they going to resolve it on a technicality type of a thing? Well, you know, he's technically not holding. Like, if they buy that argument, I don't actually like that argument, because if they say, well, Trump cannot be precluded from holding office, so he's on the ballot, then when he wins, they're just going to be a bunch of challenges saying, well, now he's disqualified under the insurrection clause. And are they going to have to revisit that whole thing? I don't know. We'll see. So that is what Trump and his team submitted. Now, Crazy Eyes Griswold, Jenna from Colorado, who we just heard and learned a little bit about here, she showed up to talk with Anderson Cooper. And so we're going to listen to her in a minute and see what she says before rolling over to Trump to hear how he anticipates this going at the Supreme Court. Now, this is Crazy Eyes Griswold here talking with Anderson. And Anderson actually has some questions for her, saying, you know, this might actually cause some chaos. President Trump might be right.
Here, senior legal analyst and former federal prosecutor Ellie Honig, and joining us is Colorado Secretary of State Jenna Griswold. So, Madam Secretary, I'm wondering what you make of the filing by the former president's legal team, particularly the argument that removing him from the ballot would unleash chaos and bedlam.
Well, I think it's really interesting they chose to use that language, because it's just more of Donald Trump saying that if he's not in charge, the country's doomed. But the language itself, on top of that, I hope is not a threat to the stability of our country. Donald Trump has used his words to incite violence on January 6th with the insurrection, and violence to election workers, judges, anybody who stands up to him and stands up for our democratic institutions. I think it's just more of the same, and it underlines how dangerous he is to the country.
Wouldn't it be chaotic, though? I mean, if voters in your state and any other state, Maine, felt that they were disenfranchised?
Yeah, Anderson, it would.
Whether or not it's violent or not, but it's just certainly chaotic, no?
Yeah, if you have 50 states doing 50 things.
Well, he used two words in that description, not just chaotic. And Bedlam. Anderson, you know, at Bedlam. The end of the day, it's my job and all secretaries of state job to uphold the law in the United States Constitution. There is clear language in Section 3 of the 14th Amendment about when elected officials or anybody who swears to uphold the Constitution engage in insurrection. It would be equally chaotic to not uphold the Constitution in this case. So I think
you can just let the people vote, rather than deciding that you're going to change the law and say that he can't even run for office now, and then have 4 Democrats throw him off. You could just let the people of Colorado vote. If they think he's an insurrectionist, well, then they could go vote for him. Because we already had a mechanism by which we tried to prosecute Trump. Remember, politically, they impeached him for the insurrection. That was the charge. And then he was acquitted on that in the Senate. And that's a representative process for the country. Okay, we actually have representatives. People vote for the representatives who go to the House. People who vote for the representatives who go to the Senate. And they get to decide. But the judges are not. And I don't know how things work in Colorado. I don't know if she's runs or if she's appointed or if she's accountable to the people. But the judges are judges. That's not part of the representative body. So it's anti-democratic as can be. But they don't care, because this is their only play. They're afraid they're going to lose to Trump.
There's lots of legal arguments.
Ellie, how do you see it? I mean, what are the odds that the Supreme Court will actually go with the president's brief?
I think the Supreme Court is going to agree with Donald Trump. I think they will strike down what Colorado has done here.
Nice job,
Donald Trump
Ellie.
makes 2 categories of arguments. One of them is factual. He says, I did not engage in insurrection. I don't know how compelling that is when you look at the facts. I don't think the Supreme Court's going to touch
It's very compelling, because nobody's charged him with that at all.
that. I do think Donald Trump his lawyers make some powerful legal and procedural arguments. For example, and Secretary Griswold mentioned the text of the 14th Amendment. Well, the 14th Amendment, Section 5, says Congress, the U.S. Congress, shall pass legislation to enforce this. It does not say Congress or the states, if they so choose. If I can ask Secretary Griswold, I'm curious what your view is, Madam Secretary, about that. The fact that Section 5 says Congress shall pass legislation. It doesn't say anything about the states.
Good question. Go ahead.
Section 3 also specifically talks about the role of Congress. And the role of Congress
Yes.
in Section 3,
That's
which
the
is the
point.
provision we're talking about, is Congress can determine that someone can be seated for office even if they did engage in insurrection by a certain amount of vote. So that is the clear language.
2/3.
On top of that, the historical record of this provision is that Section 3 of the 14th Amendment is self-executing.
She didn't answer
meaning that Congress does not and did not have to pass legislation.
No.
It has been used throughout American history without
Ellie knows. Look at this. He's like, look at his face. He's like, this woman is blowing so much friggin' smoke up my derriere right now. This is not good.
Congress first passing a law enabling it. So I do think that is an incorrect argument.
But who is the self in self-executing? Who actually enforces this?
Me.
Who makes the decision?
I do. I'm Jenna. I'm me.
Well, under the electors clause, it's the states. It's up to individual states to determine how to decide who they're going for president. That's why we have different elections in every single state. That's also why I think the Colorado Supreme Court got it right in Colorado. To your point, it is pretty evident that Trump engaged in insurrection.
No, it's not.
But on top of that,
why didn't they charge him? Why is Jack Smith charged him with everything else but not that, huh?
I would say Section 3 of the 14th Amendment is clear, and other clauses in the Constitution let states determine how to execute elections. That's exactly what's happening in this case.
I want to play, Madam Secretary, something that one of the former president's attorneys said on Fox earlier this month about what would happen if the Supreme Court were to take up the case.
I haven't seen this. Let's see. Oh,
I think
Alina.
it should be a slam dunk in the Supreme Court. I have faith in them. You know, people like Kavanaugh, who the president fought for, who the president went through hell to get into place. He'll step up. Those people will step up, not because they're pro-Trump, but because they're pro-law, because they're pro-fairness. And the law on this is very clear.
Yeah, that sounds fair.
I'm wondering how you interpret that, because on the one hand, she's indicating that Kavanaugh would step up because the former president went to bat for him. But then she quickly corrects herself and say, well, he wouldn't step up because of that. It would be because he cares about the law.
Well, the answer is that Trump fought to get good people on the court who like to follow the law and follow the Constitution, and they're not partisan hacks. And they tried to do the same scam garbage with Kavanaugh. Remember the Blasey Ford stuff? How you got attacked in high school? 35 years, however long ago that was, 25 years ago. Same E. Jean Carroll garbage. Same thing. So the point is, Trump is putting people on who are better than their side, and so they're not going to fall for this political garbage. That's all the point that Alina was making.
I just think it's so reckless of his attorney to have said that, let alone even thought it. It undermines the independence or the perceived independence of the court. But I think the bigger picture is that this is how Donald Trump operates. He wants people around him to be loyal only to him. He wants them to set aside the law, the Constitution, even so far as saying that if he would assassinate a political opponent, he wouldn't face liability. That's one of the reasons
That is not the argument. The argument is that you have to be impeached and convicted before you're exposed to criminal liability for things that are within the outer perimeter of your presidential responsibilities. But do you see, they just... Assassination. Got it. Yeah, you're very sane.
I do think he is extremely dangerous. And I think ultimately it is very likely that the American people will have a huge role in saving our democracy in the general election. And I'm not waiting for the Supreme Court to solve the big problem of democracy that we have in this nation.
Madam Secretary, I appreciate Ellie Honig as well. Tonight's other.
Okay, so it says that the Colorado Secretary of State, from their website, the mission is to ensure the integrity of elections. Okay, that's what they're doing. So she's going to be there to ensure the integrity of the Colorado election. She is the person running the elections. So it really doesn't matter if Trump is on the ballot or not. Can you imagine what's going to be happening in her office with all of the people who work for her that all have the same deluded mindset that Trump is an insurrectionist who's going to wreck the country? Look at her smile. She's whacked. So they're all going to be in cahoots, right? You know, the idea that anything, she said that anything coming out of Alina Habba's mouth is problematic. It's like, could you trust anything that comes out of her office? Nothing, because she is a weaponized partisan secretary hack. Now, Trump is responding, and she's got the craziest eyes we've seen here. So here's Donald Trump responding to some of this. He showed up on that network and talked to this guy. And here is what he said about the Supreme Court and the people there who are going to be ruling soon.
You have some other great justices up there, and they're not going to take the vote away from the people. I mean, I'm right now, you saw in the history of the Iowa primary, I mean, the history of it, goes back a long time. I won by the most. Nobody's ever won, as you know, because you covered it very well, but everybody covered it. Even the bad reporters covered it this way. There's nobody even close. I doubled up and more than doubled up the second best, now the second best. It stood for a long time, as you know, that record. But they want to make sure, I'm sure the Supreme Court is going to say, we're not going to take the vote away from the people. Now, Biden is a threat to democracy. He's an absolute threat to democracy. He's very dangerous for a couple of reasons. Number one, he's grossly incompetent, which is the number one reason. But he's also, actually, in his own way, it's not him. It's the people that surround him. You got some very bad people surrounding him at that desk. You have people running the Department of Justice surrounding him. They're young and they're smart and they're communists and they're Marxists and they're fascists. And they're running this country. They're running it right into the ground. But I don't think the Supreme Court would do it because you can't take the vote. You know, I'm leading in every poll. I'm leading Biden, but I'm leading the remaining Republicans. There's two of them, and they're barely hanging on. How can you possibly take the vote away?
Well, because they know that. They know that they're losing, and it is their tactic now. 4 different indictments, multiple fake assault cases from 25, 30 years ago from people like E. Jean Carroll, who were incentivized to run by having the whole thing funded by guys like Reid Hoffman, sold on the idea by guys like George Conway. The whole story, right? It's all concocted garbage by political opposition, and Trump is responding to it. Now, we're going to be here, my friends, continuing to cover this and more. We're awaiting the Supreme Court to have oral arguments on this, to hear all the additional filings coming in. We're going to wait for their response and their ruling, because if this comes back down and they say that, yeah, the various states can just decide, if you got to have people like this just disenfranchise the entire state of Colorado, well, that's going to not bode well for the country, in my humble opinion. And so we're excited to see what happens here. Hopefully the Supreme Court shake some sense into these people. We'll be here continuing to cover it. Thank you for subscribing as we do. Don't forget to check out robertgovea.com. The link is down in the description below. If you want to read the PDF, we upload all of our PDFs there. We've also got a great newsletter where we synthesize all of our show segments, bundle them up, send them right to your inbox, and that way you never miss a thing. So check it out, robertgovea.com. Link is in the description. We'll look forward to seeing you there and back here on the next one. All right, now, let's see what's happening over with New York. In the New York trial, Alina Habba is renewing her request for a mistrial. We're back in the E. Jean Carroll case, New York, Judge Kaplan presiding. And remember, on day 3 and on day 2, Alina Habba was really getting into it with Judge Kaplan. And at one point, we learned in the testimony that this accuser, E. Jean Carroll, a.k.a. Miss Bergdorf, who alleges she got Bergdorf in the dressing room at Bergdorf's, she admitted on the stand that she had deleted evidence. Remember, this is a case for defamation and damages. And she said, well, a lot of people sent me death threats. When Donald Trump started speaking out against me, calling me a liar, they started making mean tweets about me. And Alina says, oh, do you have those mean tweets that were all delivered to your DMs? Do you happen to have those emails? Do you happen to have those Facebook messages and so on? And she said, no, I deleted all of them. And she said, well, that's very convenient because we demanded those via subpoena. We'd like to see them. And she said, well, I don't have them. We thought, isn't that convenient? So she moved for a mistrial. Judge Kaplan told her, denied, and told her to sit down and shut up. And so she submitted this letter in. Very beautiful motion. Let's read through it. You see, from the office of Abba Madeo, from Alina Habba to Honorable Lewis Kaplan, from the Southern District of New York. She's the managing partner over there, admitted in 3 states, gosh, so smart too, filed a 7-pager. The case is Carroll versus Trump. You see, going to the Southern District of New York, Miss Habba writes, Dear Judge Kaplan, Now, this office represents President Donald Trump. Now, this letter is submitted to renew a demand for a mistrial that I made in your courtroom a couple days ago. Or, in the alternative, if you're not going to do that, we're demanding that Roberta Kaplan and E. Jean Carroll be precluded from seeking damages related to death threats that were purportedly made to her, and all testimony that was related to these so-called death threats be stricken from the public record and from the record of this trial, or in the alternative, that the court include an adverse inference charge against her because E. Jean Carroll deleted data. It was related to her willful violation of her discovery obligations, and she spoiled the relevant evidence that we need for our defense. Ms. Habba says, Mrs. As Your Honor is aware, during cross-examination on January 17th that we covered here, plaintiff E. Jean Carroll was specifically asked about the deletion of emails, which bear direct relevance to this instant action. Now, in response, E. Jean Carroll on the stand, she admitted that she deleted multiple email messages pertaining to death threats that were made to her. Now, here's what the trial testimony that was provided by her sounded like, Judge Kaplan, in case you forgot. Question from Ms. Habba. E. Jean, now you said that you received threatening messages in your testimony. Remember saying that today, correct? Yes. And you deleted those messages? Yes. And do you know what happens when you delete a message from your inbox? Well, it goes into the trash in my computer, and then the trash is emptied automatically every 30 days, I think. Oh, so you knew it was going to be deleted. Did you ever delete the emails from the trash section of your email? So like you deleted it and then go in and delete that? I probably did. So your testimony, E. Jean, is that you deleted the messages and then they went to the trash and then you went into the trash and then you deleted the trash as well. Is that correct? Well, I didn't go into the trash. I just periodically empty my trash in my computer because it's an old computer and it tends to slow down if I have a lot in the trash. Did you stop deleting those threatening messages at any point, Miss Carroll? Yes, I did. Well, what was that point? Actually, I went on deleting most of the replies. I stopped right around the second lawsuit, the one in May, I stopped. So the first trial we had was when you stopped deleting them. Is that right? Well, no. That is correct. I don't remember deleting any around that time or since then. Habba says, I'm confused, Miss Carroll. You stated in your testimony today that you received death threats daily. Is that correct? Well, not daily, but often. Okay, so often. And you deleted those messages all until you were in the middle of trial? Is that your testimony today? No. Okay, so please explain to me what you meant by that, Miss Carroll. The court Kaplan jumps in. Explain what she meant by what, Habba? Habba says, well, when did you stop deleting the death threats, E. Jean? I generally got rid of many of the replies on Twitter and on Facebook. I would just delete. I did not delete my post. I just deleted the replies. I hadn't realized how many death threats there were in my private messages. Ms. Carroll, my question is, thank you for that. When did you stop deleting them? The messages that you just spoke about, when did you stop deleting them? We've been litigating this for years. Probably 2023. Lot of deleted messages here. Curious. So Alina says, all right, Judge, listen. Now, based upon that trial testimony that you just heard, E. Jean admitted to deleting evidence that was clearly related to this litigation in direct violation of the rules of civil procedure. Now, the rules say that anything that's electronically stored be preserved for litigation. Now, she acknowledged, E. Jean, under oath that she violated the rules. Despite being served with a subpoena in connection with this action, E. Jean failed to take reasonable steps to preserve relevant evidence. In fact, she did much worse. She actively deleted evidence which she now attempts to rely on in establishing her damages claim. She says these are so hard and I'm in so much pain. And I deleted them all. Now, accordingly, it is beyond dispute that plaintiff's failure to comply has caused significant prejudice to Donald Trump. And so now, Alina says, I am renewing my request that I previously made on the record for a mistrial. I said, Your Honor, at this moment, I feel I have to ask for a mistrial. The witness, E. Jean, has just admitted to deleting evidence herself, which are part of her claim of damages, and I haven't seen them. She has no evidence of them. She hasn't turned them over, and they're gone. And now she wants my client to pay millions of dollars for missing evidence. Alina says, whereas here, the nature of the alleged breach of a discovery obligation, is the non-production of the evidence. Where they don't produce the evidence, the district court has broad remedies to decide the sanction. Now, this is a defamation action, and the ongoing trial here is centered around her claims for damages. A significant component of her claims is directly from the death threats that allegedly she got. She said this during her testimony. She said, my brain just froze. So to make myself feel good, I went to my Ask E. Jean website thinking that I'd feel better if I could read some support. Now, and I opened it up, and yes, there was a really lovely email, saying, you go, girl, yeah. And then I opened up the next email, the next Ask E. Jean letter, and I looked at it, and I read it, and I ducked. Because the image of what that person said caused me to believe that it was going to happen right now. I thought I was going to get shot. And what the hard part was, I couldn't get the curtain across the window closed. I was sitting in a room with an open window at 11:30 at night, and it's when you see the words, the image comes into my mind that I believed it was happening right now. So I deleted the message to protect myself. She's like crazy, man. Like, I don't know what the image was. If there was an image, I think she is saying, I read an email. I opened up the next letter because the image of what the person said, so it was like a written thing. So they wrote something, and I thought it was going to happen right now. So it popped an image into her head. And so she's so deluded that she thinks it's happening. I think I'm going to get shot. Why? Because someone sent you an email? Weirdo? So do you also think that somebody is attacking you in a dressing room at Bergdorf's, like when you watch an episode of Law and Order or something? Because that happened in that show. So she's like almost, unwell, just coming up with these images in my mind. When you see the words, the images come into my mind. So people just pop stuff in there. I believed it was happening right now. Wow. So you're like crazy. You just like make up stuff. Like you think is Mr. Bergdorf in this room right now, E. Jean? Where is he? Is he touching you right now? Is the dressing room door here too? So I deleted the messages. Now, as stated above, E. Jean recounted to the jury that she received vicious death threats on June 21st, which she directly attributed to Trump. And so she thought and she sought to substantiate her claim for emotional harm by describing how she felt like an attack would happen right now. Her heart would race. However, it cannot be established that those messages even exist because she deleted them. Now, even assuming that the messages did exist, the question of when they were sent is material and pertinent to Trump's defense. Now, one of the consistent themes throughout this trial has been the causal link between Trump's statements and the damages that went to her. Now, there was a 5-hour window between the time that the cut article from her was posted and the time when Trump issued his first denial. He doesn't even know about it. Media asked. I never heard about it. Plaintiff claims to have received at least 2 death threats on that same date, but she deleted those. Now, then she said that she did not recall what time the messages were sent to her, so we don't know. If someone read the article and heard the news and sent them, or someone heard Trump and sent them, because we can't know, because she deleted the evidence. And since the messages have been deleted, this information is unknowable, so we have no idea. Now, critically, Alina says if the June 21st death threats had been issued during that 5-hour window before Trump even ever spoke about her, it would conclusively establish that they're not the cause of Trump. That would undercut any of her arguments. And since they say she was receiving similar messages in the immediate aftermath of the article, so it didn't come from Trump. In sum, it's clear from the testimony set forth above that Ms. Carroll sought to circumvent the rules of procedure. She not only failed to preserve her evidence, but instead knowingly deleted the messages that contain the threats. This is a procedural irregularity that is not only appropriate for the court to grant a mistrial, but it's actually essential. Her failure to preserve this evidence in contravention of the rules severely prejudices Trump and his defense, as he's been deprived of critical information necessary for his defense. And so we ask that you declare a mistrial. Now, all of these damages should also be precluded. Anything that's related to her death threats claim should not even be considered for damages. Here's some more from the trial. Ms. Carroll, says Alina, when was the first time that you publicly revealed that you had been received death threats? First time publicly. At the last trial in May. Were you also receiving death threats, Ms. Carroll? Yes. I'm confused. You stated in your testimony today that you received death threats daily, right? Not daily, but often. So all your death threats that you received that frightened you, they were in writing. Is that correct? Yes. So 4 examples of those, right? Now, as set forth in multiple transcripts, she's testified about death threats on multiple occasions. Her receipt of these messages is a significant portion of her entire claim. Yet, while she claims that she did receive numerous threats, she did not provide any specific testimony about any of the purported threats, with the exception of those she claimed to have gotten on June 21st that she subsequently deleted. And so during cross-examination, she admitted there was a 5-hour gap in between the time that the cut was released and the time that Trump made his statements. Habba says, that was not my question, Ms. Carroll. Now, there was a time when you put out the article, the cut article, and when President Trump made his statement, there was a time between those 2 incidents, right? Right. And if I told you that was about 5 hours, would that sound about right? She admits, yes. So it's undisputed that there were malicious tweets directed at her during this 5-hour period and when Trump made his statement. Now, as explained above, there also is a substantial likelihood that the death threats that she received on June 21st, that she referenced in her testimony that's a part of her claim for emotional harm, they were also sent during the 5-hour window. And so if that is the case, then her entire claim for emotional harm is undermined, because it would show that she got death threats before Trump said anything. And therefore, she cannot establish a causal link between the death threats and Trump's statements and prove that it was from Trump and not the magazine. Also, Eugene admitted to knowingly and repeatedly deleting email messages that contained the threats. Delete this, delete that. Plaintiff further admitted that all the death threats that frightened her were sent in writing. And since she clearly failed to preserve the evidence about which she complains today, we can't see whether the contents actually mirrored Trump's statement. They said, well, it sounds like Trump. Well, did it? We don't know. We can't read it. As such, due to the deletion of this evidence, we can't suggest a causal link. And so accordingly, for the foregoing reasons, we request that anything that comes from damages about the death threats alleged, all is precluded. Now, in the alternative, if you're not going to dismiss her claims, we want an adverse inference instruction. So you tell the jury that she deleted the evidence. Tell that she was in sole possession of the death threats and she intentionally deleted them. Put in there that this was relevant to Trump's claims, and now he can't make a defense about causation. And so permit an adverse inference, punish her for deleting the evidence. So add a jury charge to the jury instructions that they may draw a negative inference against her deleting the evidence about which she claims is so damaging. Alina says, for the reasons above, we want a mistrial. And we also want that she be precluded from seeking damages about the death threats. And if you don't declare a mistrial and dump this, then the court include an adverse inference when the case is handed off to the jury, so that they know that she violated her discovery obligations and she spoiled the relevant evidence. Great motion from the one and only Alina Habba in the House. And so we're very much looking forward to the judge denying this on all accounts, just to be perfectly clear where this is going to go. Judge is going to say, no. It's all close enough. It's all relevant for damages. The deletion was not relevant. There's plenty of evidence here they've already provided, and that it's close enough, essentially, is what we'll see. And the judge will concoct a reason for it. So we'll be here continuing to cover this. We'll see what happens when Roberta Kaplan responds to this. She's going to oppose a mistrial, and then Alina will, of course, get a ruling from the courts. We'll be here as it continues to go down. Trump is scheduled for a possibility to testify when the trial is back in session on Monday. We'll be here continuing to cover this, my friends. Thank you for subscribing and sharing this video wherever it is you're watching this. Thanks for checking out robertgovea.com. Link is down in the description below. Of course, that's where you can find the PDF that we just read. That's where you can sign up for our daily newsletter, and we'll look forward to seeing you there and back here on the next one. All right, my friends. Now, we've got one final motion on the day. Two motions, actually, to read. And this one involves Fulton County. Woo! And this is going to be juicy. And that's a careful adjective when you're talking about this segment. Let's get to it. Fani Willis freaks out, sends an emergency motion. She has been subpoenaed to show up and testify in Nathan Wade's divorce for a deposition. And Fani does not want to do that. Now, we already know Nathan Wade, the special prosecutor, had his entire divorce sealed. He doesn't want anybody looking into it. But we've got a lot of activity in this case. So as JOCEYLN, the loving wife of Nathan, has to survive this divorce, she has submitted a new response because Fani is now trying to get out of the deposition. An emergency motion was sent. Jocelyn Wade responded. And we're going to hear from this person called Unwind with Tasha K, another YouTuber, for some reaction to this whole saga. And it's getting wild. But let's dive into this because Fani is saying, I don't have to show up. I don't have to be there to appear to be deposed. And this is coming from Fani's office. Let's take a look at who signed off on this puppy. Right here, attorney for the non-party deponent, Sink Axum. And this is the subpoena. So this is what Fani ultimately got. Signed by this judge. And it says here, Fani, Miss Fani Willis, you have to get your booty right over to court to testify. You are commanded, laying all business aside, to appear at this date and time, January 23rd, 2024 at 10 a.m. at this law firm, to show up in our conference room and be deposed. Signed by the judge and delivered. And Fani is saying, uh-oh, I definitely do not want to be a part of this. And so she responded. Now comes now Fani Willis, Nathan Wade's alleged paramour. She's a non-party deponent. And she says that she's moving this court for a protective order. She wants to quash the subpoena and get a protective order over her so she doesn't have to participate. Why? Because the very loving Jocelyn Wade, who was married to Nathan for over 20 years, raised their kids, sounds like a stay-at-home mom, she's getting divorced now because Fani wrecked their home along with Nathan. He's very responsible for this, to conduct a deposition of Willis on January 23rd, which we can't wait to see what happens. And so they say, now we're arguing against this. Now, Fani, she is going to come out swinging. Don't you know who I am? Fani Willis is the elected DA of Atlanta Judicial Circuit, like Fulton County. She was elected back in January 2021. And now this county, they executed a contract with Nathan Wade, which is the legal entity that employs Nathan Wade, his professional corporation. We executed the contract, and the contract began November 2021. The day after he got the contract, he filed for divorce. Now, as part of the contract, Nathan Wade was a special prosecutor prosecuting Trump. On January 8th this year, Jocelyn Wade, the ex-wife, through her attorney Andrea, they tried to serve Fani with the notice of a deposition. They went to her office, and Fani was hiding around in the in the office somewhere. They gave it to her assistant. Jocelyn Wade is the wife of Nathan, who is the special prosecutor Nathan Wade, her ex-wife. He's the ex-husband. Now, the subpoena was presented to an employee at Fani's office. Then Michael Roman, through his lawyer, filed a motion to unseal this, along with a very explosive motion about Fani and Nathan. Now, additionally, the same date that Roman filed that whopper of a motion, he also filed the disqualification. So he filed in both cases the same date, right? And they're saying this feels like it's a hit job. So Michael Roman filed through Ashley Merchant 2 motions, one to unseal the divorce case and one to disqualify Fani and Wade, saying there was a conflict. So here's what Fani says, saying a protective order should issue and the subpoena should be quashed. Why? Well, protective orders, they say, are very important for high-ranking members of governmental bodies. And you know Fani, the biggest Fani in Fulton County. There is no serious dispute that Miss Willis is an officer as defined by this. And so she is high-ranking, obviously. This is the don't you know who I am section. More importantly, Willis lacks unique personal knowledge, yeah, right, of any matter that is related to the subject matter involved in the pending action. Give me a break. Fani was getting Willised by Wade all over the place. Okay, she's got a lot of personal, unique knowledge. Gross. Now, indeed, the deposition of District Attorney Fani Willis, they say she can't give you any personal knowledge about Wade's divorce because plaintiff filed for divorce on November 2nd, right? The day after they got the contract. So she says we executed the contract. Did she notice that little connection there? Yeah, the contract commenced in November 2021. Notice how they didn't put the date here. What date was that? Commenced in November. They left out the date intentionally. Commenced on November 1, 2021, right? The next day, oops, November 2nd, he files for a divorce. Ooh, man, I love this new gig. This Trump money's good. He said, well, weird. I've got this grand new contract and suddenly my marriage is irretrievably broken because there's a new Fani in town. The defendant, Jocelyn, answered and she agreed. The marriage was irretrievably broken. And so she, presumably at the time, she didn't know about that dude's contract. So examination of the docket reveals that for the prior 26 months to attempting to serve this woman, Fani, the parties have not amended their pleadings. Oh, gosh. And they just maintain that it's irretrievably broken. So there's no allegations of infidelity or anything else. So it's already well established. This case is over, Judge. I mean, look, it's been going on for a long time, 26 months. It's been going on and on and on. So we don't need to unseal this, okay? They've already both decided, both parties already agree it's irretrievably broken. And so that's a legal conclusion signifying there's no hope for reconciliation. And so there's no genuine issue of fact to even remain to talk about. So you don't need to talk about to Fani, because if you talk to her, what are you going to talk about? Money, infidelity, different things that break down. But since they both already agreed 26 months ago that it was already irretrievably broken, we don't need to get back into it. And they give us some cases here. They say on information and belief, says this attorney for Fani, Nathan and Jocelyn, they do not live together. And Jocelyn has lived outside of the state of Georgia and separate from them since 2021. Thus, there is no, well, of course, he's filed for divorce. He's like, so she's split. Thus, there is no prospect of reconciliation or genuine issues of material fact that need resolution. Jocelyn Wade is not alleged otherwise. In fact, Jocelyn has not made any specific request from any information from Attorney Willis at all. If, however, media reports are any indication, Jocelyn may intend to ask questions about the nature of any relationship between Fani and Nathan. Now, because the parties agree the marriage is already irretrievably broken and the concept of fault is not at issue, there's no information that Willis could possibly provide that would either grant or deny the divorce. It's not relevant. Thus, any information from Fani would be irrelevant. Now, as a result, the sought-after deposition, dragging Fani in there, is outside the scope of the pending divorce action. It's outside the scope of discovery, saying Jocelyn is using discovery as a vehicle, to harass Willis. Scorned ex-wife is harassing the DA, says Fani. So in other words, Fani wrecks the home, hires her mentor, so-called, gets Waded and Willis all up and down the Caribbean, or wherever they were, on cruises with the Royal Caribbean, pays him $1 million. He leaves his wife the day after he signs the contract, presumably doesn't tell her anything about any of this stuff, makes $1 million while he's still technically married, hides all the money or whatever he's going to do, takes her on these cruises and stuff. And then Fani says, how dare you harass me by wanting to know what happened? Nice. That's Fani. Now, the sought-after deposition of Willis is not relevant to this divorce at all. And so for these reasons, we need a protective order. Saying there's no basis for this at all. They already agreed that their marriage was irretrievably broken. And here, prior to Wade ever meeting Willis, wait a minute. As early as 2017, prior to Wade ever even meeting Willis, the parties to the above-style divorce, they already agreed that their marriage was irretrievably broken after Jocelyn. Oh, no! Jocelyn confessed to an adulterous relationship with Nathan's longtime friend. The tables are turning. They're both getting fannied. Oh, gosh. What's going on over there? So now they're throwing her name in it, right? Oh, she cheated on him. So Jocelyn's adultery precluded any chance of reconciliation. So now Nathan's the victim. Nathan's wife was cheating on him, and so he fell into the arms of Big Fani. Oh no, as they're going to go and prosecute Trump and save America together. So to protect the interest of both parties, plaintiff Nathan and Jocelyn, they agreed to seal their records in their divorce case. Now, however, the parties delayed the filing for the benefit of their children. So back in 2017, they were both making, or at least she was making bang bang with other dudes. Apparently his friend, his longtime friend. What's going on over there? Who are these people? Gosh. So then they said, well, we're going to wait from 2017. We're going to wait 4 years. We'll file for divorce in 2021. This dude conveniently just does it the day after he signs a fat contract with his new Fani. Man, I don't know what kind of household this is, but it's a mess. Specifically to allow the children to reach the age of majority. So here, Jocelyn Wade has not objected to Michael Roman's motion to unseal. And the proceedings, despite having previously sought it and having benefited from this protection, now she wants to unseal it. On further information, they say the subpoena for the deposition of Willis is being sought, in an attempt to harass and to damage her professional reputation. It's also being sought in an unreasonable manner to annoy, embarrass, or oppress the deponent. And on further information and belief, Jocelyn Wade has also conspired with interested parties in the criminal election interference case to use civil discovery process to annoy, to embarrass, and to oppress Attorney Willis. In support of this contention, they're going to give us the following. Wow. Okay, so Fani, the Fulton County DA, is now almost threatening criminal charges that Jocelyn is conspiring for, defending herself in this case. By the way, we don't know her story yet. We haven't heard from her at all. Maybe Nathan was cheating on her first. We don't know. We're going to hear from her in a minute, though, because she's coming up next. So they say Jocelyn has conspired. I guess maybe she should be indicted. She's probably an insurrectionist now, to use discovery to harass and to oppress Willis. Now, in support of this, they say, a defective subpoena for the deposition of Fani was conspicuously coordinated with the election interference case. She got served and the motion to dismiss got filed. That's called law, Fani. That's called litigation. It's not a conspiracy, weirdo. Specifically, criminal defendant Michael Roman filed a motion to unseal the divorce records the same day that JOCEYLN tried to depose Fani. Yeah, they're tag teaming, man. Yeah, they're coming at you hot. Now, that's what you get. Yeah. Now, prior to attempted service of the subpoena, Wade and JOCEYLN filed a consent motion to seal. That was back in 2022. It was only after JOCEYLN sought to subpoena Fani because she learned about the millions of dollars like all of us. It's like, yeah, well, she's just acting recently. It's like, hello, we all just learned this dude got paid $1 million from Fani's coffers. Until then, it was uncontested. It was no fault. They'd already been separated for 2 years. Now it suggests that she's conspiring to use the legal process to embarrass Fani and to interfere with ongoing criminal. That's a crime, okay? Interfering with criminal, that's a crime. They're threatening her. So on information and belief, they say because the parties, because they have no minor children, they're all grown up, and because they each contend the marriage is irretrievably broken, the only potential issue may be relevant to Wade's current employment would be the salary and the division of marital property. But even this is not an issue that's in dispute. Even if it were, Jocelyn Wade has acknowledged through lawyers all financial documents she received. Custodian of records also gave Jocelyn Wade all the documents related to Wade's compensation. And so as a result, she's released from deposition the deputy of operations from Fulton County, and Jocelyn Wade has not identified any other relevant basis for interviewing and deposing Fani, saying, if you do make Fani be deposed, it's going to be overly burdensome. Well, you only gave us 15 days to comply, and the notice is too overbroad. By the way, Fani doesn't know how broad this is going to be. We don't know if it's recorded, written, transcribed, or whatever. We don't know what information is being sought. So it's way too overbroad, and it's not specific enough, and so therefore, we need a protective order to protect Big Fani. This court, they're asking, grant a protective order, quash the subpoena so she doesn't have to show up. They want Fani, she wants to be awarded attorney's fees. Oh my goodness, why? So she could take Nathan on another cruise? And they also want, in the alternative, that Fani be given 180 days to review the filing. So in other words, don't let her be deposed soon. Let her be deposed 6 months from now. And then lastly, barring a protective order, they should say, if you do make her come and be deposed, make them provide a scope of the information that they sought, the method of the deposition that they want to perform, and how this information comes out. Signed by Cinque Axam, an attorney for, I don't know what entity, but representing Fani's office. So, man, they really threw Jocelyn under the bus there, didn't they? Well, Jocelyn has a response to this. Let's see what it looks like. Jocelyn Wade, ex-wife of Nathan Wade, special prosecutor to Big Fani Willis, filed the response to Fani's emergency motion, saying, this is Jocelyn Wade here, and we're responding to Fani. They say non-party Fani, she seeks this court's intervention. She wants a protective order because she does not want to be deposed. Now, the arguments asserted by Miss Willis, first of all, they're disingenuous, they're specious, and her claimed basis for the same fails as a matter of law. Jocelyn's team says, upon information and belief, Miss Willis has information and knowledge directly relevant to the alleged conduct of Nathan that would be considered by the court as equitable division of marital estate, dissipation of marital assets, and spousal support. And further, Miss Willis's implied threat to pursue charges against Jocelyn Wade and her counsel based on inconvenient facts from her personal life that are directly relevant to the divorce proceedings is an affront to the integrity of her office. That's what they do. This is why it's dangerous to prosecute or to challenge these people. They go mental, and they'll use this stuff, right? If these people weren't lawyers and this wasn't a national case, you don't know what would happen to these lawyers. They may not even bring it up if there wasn't coverage on this. Now, Jocelyn's wife. Jocelyn continues as the ex-wife. Now, contrary to the assertions in her motion, Miss Willis Fani, her prevarications regarding Jocelyn's conduct in her marriage seems to demonstrate that Miss Willis does, in fact, possess intimate information about the Wade's marriage. Oh, albeit false and libelous misinformation. Boom! That's what we're talking about, baby. Shout out to Jocelyn. She says I never did that. And it's libelous. I'm not a cheater. And that's a great point, isn't it? Wow, that's curious, Fani. How do you know about Jocelyn? What do you know so much about Jocelyn's infidelity for? And this could be interesting. Now, we haven't read any of this yet, but what if Wade was making that up to tell Willis? He's like, no, baby, our marriage is broken. We're not even talking anymore. She cheated on me with my best friend. Never happened because he's trying to tag team the Fannies, you know? Scandalous. Anyways, now they say here, Nathan Wade, this is Jocelyn. Nathan Wade says, Nathan Wade was appointed. Jocelyn says Nathan Wade was appointed as a, sorry, I saw this, all this scandal. You know, it's hard for me to make do of what's going on here. Nathan Wade was appointed as a special prosecutor by Fani on November 1st. Then Nathan filed for divorce the next day. Jocelyn was served by a process server on November 3rd. Brutal. So before Jocelyn even filed her answer and counterclaim, Nathan filed a motion asking the court to seal the record in this action. Boom, boom, boom. She didn't even respond to this, and Nathan was already covering it up because he knew he was in some deep fanny. Now, Nathan did not reveal to Jocelyn his appointment by Miss Willis or the substantial income that he's been receiving throughout this divorce case as a result of that appointment. And Jocelyn did not discover the same until much later in the proceedings. Now, Nathan also left Jocelyn with very little means of financial support while simultaneously spending tens of thousands of dollars per month on a very lavish lifestyle. Nathan willfully failed to comply with his discovery obligations in the very divorce case that he initiated, which led to the court holding him in contempt of this court's order on our motion to compel his discovery. So that's some procedural history for you. On December 22nd, Nathan only produced a portion of his outstanding discovery responses. Now, in these responses, there were credit card statements which demonstrated that Nathan, this is recently in December, he then turned over stuff and boom, there's credit card statements that we're going to look at, that he had paid for and taken trips unrelated to the work for Fulton County's district office. Since Nathan filed for this divorce, it was him, he has taken trips to San Francisco and to Napa Valley. He's gone to Florida. He's even gone on Caribbean cruises. They enjoyed a trip to Belize, another to the country of Panama. And even just last month, they took a trip to Australia. This is crazy, man. Oh my gosh. No wonder they're handing out diversion offers to Sidney Powell. So the evidence is, they're not working. The evidence is clear. And how are they billing all of these hours? Okay, this could like seriously be fraud. If you went through and you corroborated these dates, like was he billing when he was on his trip to Australia? And what was he billing for? That's a lot of travel, man. And that's not Trump prosecution travel. Now, the evidence is clear that Fani was an intended travel partner for at least some of these trips, as indicated by the flights that he purchased for her to accompany him. And it's money laundering, really. She can't pay herself money to go on this stuff. So she hires her lover, pays him the money. He bills it as legal work, and they go on the trips. Now, here are true and accurate copies of credit card statements that shows the purchase of these plane tickets. So let's maybe Fani should be indicted for fraud. So here are some of the transactions. Let's take a look. This came from Nathan Wade's credit cards. Capital One Business. This was from April to May of 2023. And remember, Trump had not been indicted yet. Trump got indicted in August. So what are these two doing? Oh, he had to pay his bar dues. Ugh, hate having to pay those every year, hundreds of dollars. He went to Framebridge, whatever that is, $300 there. Then, oh, look at this. We have a Delta airline from Atlanta, Georgia. Destination. Oh, yeah. This one, origin, destination from Atlanta to San Francisco. SFO, San Francisco. Maybe they're going to Napa Valley. We don't know. But this is Nathan Wade's name, a Delta airline ticket, April 27th. Look who's right under that. Fani Willis. She's going to San Francisco too. Isn't that nice? Now, apparently they might have had a bug problem. Here was another flight. Oh, he's ordering flowers. I guess those flowers are probably not for his wife. Comcast cable bill comes out. Then they show up in Doubletree, Napa Valley. Isn't that beautiful? Now, do we have time? When were they coming home on this? We don't know. So lots of Ubers, probably still, right? They travel there. They meet with maybe pencil neck Schiff, whatever, who knows. Then they've got some Ubers and some wine just to ride out the trip. Here's some more. This one, some more Delta Airlines, Uber, Target, Rum Runners Freeport, Rum Runners Freeport, Norwegian Sky, whatever that is, shopping at Kroger, going to Macy's. Here's some more stuff. Trips to Uber, Hyatt. Oh, a Norwegian cruise line. How much is that one? $3,000. Yeah, that's an expensive one. That's that Trump money, man. And they're staying at the Hyatt Regency in Aruba. And all the Ubers. And so is there plane records for that one? Oh, this is just great. Oh, it's too funny. I can't even take it. All right. So look what they did. Hey, honey, what do you want to do? You want to go on a cruise? Yeah, that sounds great. Okay, I'm going to get 2 tickets. That one's $1,300. That one's $1,200. Couple tickets for this one. October 5th, Royal Caribbean Cruise. Royal Caribbean Cruise. Now this one, we got some airline, we got some tickets. We got 3 tickets here though. So who is this person? Clara Bowman. She's going, yeah, they're all flying. No, that's a separate location. I think. So this one's going from Miami to Dallas-Fort Worth. What's IAH? So I think this person's traveling separately. I don't think this person's going on the cruise. So Bowman Clara is going from Miami, ending up in Miami, traveling around from IAH. What is IAH? IAH is Houston. Okay. So that's Bush Airport in Houston. So originating and then going. So this person's traveling around. Now this is Nathan Wade and this is Fani Willis, Houston. So Fani and Nathan look like they are getting on the cruises. And I don't know who this Clara Bowman is, but maybe an assistant, somebody else are just flying around. Okay, my alternate explanation is that Nathan, okay, one of these tickets is for Clara Bowman, who is another woman. I don't know who that is. Definitely not his wife. And then one of these tickets is for Nathan, right? Like that's, maybe one was for him and one was for this Bowman person, but because she was also going to Miami. They were also taking their cruise from Miami. But I don't know. Oh, they stayed at a Holiday Inn Express. And look, yeah, here's even more airplane flights. Fort Worth, Texas, Nathan and Fani, right there. Boom. October 13th. So you can see how those can line up. Here's another one, more tickets, Nathan and Fani, all there. And so, man, they were just traveling around together, going on cruises. And here's the deposition. This is what they wanted. They want a deponent romantic relationship. They want it videotaped with a court reporter, sent over to Fani. Now, what is this? Your package has been delivered. Oh, we got a package delivered. FedEx shipment. Your package was delivered to Mrs. Fani Willis. Oh, that's the service. That's Fani's office. From the law firm saying you're being deposed. We sent that over also. This is our affidavit of service. So this guy tried to serve Fani. He showed up to her office. He said, I personally appeared. I served Miss Fani Willis with a depot by leaving documents with this person called Tia Green, who's the executive assistant to Fani. Fani ran out she's hiding in her closet. Like, no joke. And then they served her assistant. She's a black female, age 45, 5'9", 170 pounds. All right, so those are the documents. Now, we got those credit card transactions there, and it sure looks like these two traveled to Napa Valley together and hopped on some cruises. Went on like some Norwegian stuff going on there. Looking at some other big expenses. Bursar Operations. I don't know what that one is. That's a $7,000 expense, though. That's a pretty serious one. Is that? I don't know what that is. Is that a cruise? Or something? Anyways, okay. So those are the documents, man. These two were just lounging it up on that good Trump money. So here we know, apparently they definitely purchased plane tickets for her. So here's where Jocelyn's team continues. They tell us, now Jocelyn seeks to depose Fani. Why? We got to determine the details around this affair with Nathan. There appears to be no reasonable explanation for their travels other than a romantic relationship. Saying Miss Willis contends in error that the parties both, citing in their divorce pleadings the no-fault provision of irretrievably broken, that it means that Jocelyn's inquiry into his infidelity is impermissible. But that's mistaken. Sorry, Fani. In Georgia divorce proceedings, a party can amend a pleading all the way up until the entry of a pretrial order. And because we have no pretrial order here, we can amend this, which means we are going to. Furthermore, a party to a divorce is not required to allege adultery in the complaint to present evidence of the same. Now, although Jocelyn was unaware of a romantic relationship between Willis and Wade, the Court of Appeals has said that you can engage in discovery when there's evidence of adultery. So parties can obtain discovery, and that's what we're doing here. Now, contrary to Willis's, Fani's belief, Jocelyn is not utilizing this deposition to harass her, no. But instead, we're trying to seek pertinent information from Nathan's paramour regarding her relationship with Fani and to the extent of Fani's financial involvement in this case. These answers are relevant. We're talking about equitable division of the marital estate and the disposition of Wade's assets and the marital assets and her capacity to provide spousal support. But Willis mistakenly relies on the wrong law. Protective orders don't work that way. Miss Willis certainly would have unique personal knowledge of the romantic relationship that she was having with Nathan and the trip she took with him either before or after the divorce was filed. And so, therefore, her argument lacks merit. It's like, we know. She was traveling with him. Clearly, he bought tickets for it. So how can she explain that? That's material. Now, as for Fani's argument that the subpoena was defective, the subpoena, which came from and was sealed by the clerk of the court, was properly served by Georgia law, and a notice of the deposition was also filed with the court and served properly. It would be impossible to obtain Miss Willis's home address due to her position, meaning her address is shielded from public view, so normal techniques would not be able to identify it. The process server effectuated notorious service with Tia Green. She was hiding in her closet. It should be noted that after a previous attempt to serve Miss Willis at the county office, we already tried to get her. We couldn't get her the first time. Then we served her assistant, and Miss Green represented that she was authorized to accept service. We looked at that affidavit. However, in an abundance of caution, we have also served a new subpoena upon Miss Willis with a statutory overnight service congruent with another part of the law. So we've served her multiple times with this. The service is valid. Her allegations otherwise are nonsense. In her motion, Fani has presented extensive and personal information about the Wade marriage, which was totally inappropriate, by the way. And I should have hit that harder, but it's what she's trying to do is drag the other party's name through the mud. Okay. And by the way, the first filings here did not do that. Like the first filings, like they revealed some information about Fani and Wade, but they were trying to hold back. Fani just came out and called her an adulterer. You started it first. So these are also including false allegations that she engaged in an affair in 2017. However, the evidence will demonstrate that Miss Jocelyn Wade did not have an affair. Jocelyn was experiencing a profound sense of disconnection in her marriage with Nathan, who had essentially ceased investing in their relationship following Nathan's own actual infidelity. Oh, man. Jocelyn, we apologize for doubting you. We're sorry this is happening to you. We're on Team Jocelyn now. And so she got cheated on, and she was feeling lonely and isolated. And so she reconnected with an old friend through social media, but text messages were the sole extent of their contact. So Nathan and Jocelyn, they successfully worked through the issue, as evidenced by the fact that it was not until 4 years later that they filed for divorce. It's crucial to emphasize that Jocelyn never met this person that she was texting with, and she had no physical contact with him, and she certainly didn't go on any travel with him, like to Napa Valley. So Jocelyn and her lawyer intends to, among other things, examine Miss Willis's actions. We want to know what she knows about these allegations that she's made against Jocelyn. How did she get this, quote, information? Was that pillow talk from Nathan? I probably was. No, listen, baby, she cheated on me first. Our marriage is really on the rocks, like it's not even a thing. Yes, I'm coming over tonight. Yes, I'll pick up some Chinese food. No, my wife doesn't care. As well as regarding her own personal relationships with Jocelyn. And so he's telling her, and Fani throws that in motion that she didn't have any real knowledge about. Wow. Now, allegations about their marriage contained in her motion raises the question of whether Miss Willis possesses equal intimate knowledge of any marital discord involving any of her other special prosecutors. Yeah, does she know anything about that white guy's marriage who she paid a lot less? Her public inquiry of, quote, why the one, seems to be met with a response that suggests because you, Miss Willis, are having an affair with him and not them. Yeah, we made that exact point as she was speaking there in that church. Well, did you sleep with them? Why not? I mean, maybe she did. I don't know. We don't know if she slept with the white guy or the white woman. I don't know what's going on there. Sounds wild there in Atlanta. So it is regrettable that Miss Willis has filed such an inflammatory motion. She did. She was threatening them. She was smearing her name in it, which has left Jocelyn with no other choice than to respond forcefully and with supporting evidence in a case that is very personal in nature. This is going to get bloody. Perfect. Jocelyn's sole objective is to lead a peaceful life, and her counsel is committing to ensuring that she has adequate means to support herself and to defend herself in this litigation. If non-party Fani seeks protection, it appears the one that she needs protection from is herself. And so we ask this court, deny her emergency motion and allow us to depose her. Signed by Andrea Dyer Hastings, Georgia Bar, and others, on behalf of Jocelyn Wade. Shedding the light on these flowers and Uber trips and Napa Valley DoubleTree Resort extravaganzas and cruises and flying on Delta Airline, all exposed from Big Fani by Jocelyn Wade. And this is another YouTuber, my friends, who had an excellent take on this and can put it in only a way she can. Hat tip on this one to Julie Kelly, who is explaining what this sounds like, calls it Housewives of Fulton County. Julie Kelly does amazing work, by the way. If you're not following her, you absolutely should be. And this comes from a woman called Tasha K. She's also on YouTube, and you can subscribe to her if you'd like to listen to more of this amazing content, which I would encourage you to do, because it's amazing. Here's what it sounds like, talking about Fani and Nathan. This is Unwind with Tasha K.
What about Nathaniel's wife?
And real quick, if you got children, put some earmuffs on or put them to bed quickly.
Fani? All that money you allocated tricking on a prosecutor, tricked his wife out of $1,400 a month alimony payments, and even took some of it back using the debit card out the same account that he put the money in from contracts he allegedly fucked you for. Where's the justice for this black woman when she's saying I've been married to his ass for 26 years?
That's true.
Raised his children, and he somehow found a way to get around the law to only pay me $700 every 2 weeks, and then he splits that with me? This is the one you getting up on a church podium here
Yes.
to stand beside?
Yes. That's her. Yeah.
That's the problem.
Yeah.
Women findeth men. How you in church talking about, when I found this black man, you didn't find him.
He was married.
He's fucking you. Full way up. That's just what it is. And you didn't think that they was gonna find out. But I'm just like, where's the justice for this black woman over here?
Oh, there isn't.
That helped to build up the very man that you are enjoying right now for the small price of $630,000 every year.
Boom. Wow.
So the state's money. Now, who paying that money?
Fulton.
We got questions.
Yeah, we got questions about it.
We got questions.
Okay, so you can see this racist white male is a bigot and who is illegally targeting Fani for criticism. You know, she didn't even talk about the white guy either. You know, it's really ridiculous. Clearly a racist statement who is attacking Fani for her transgressions totally inappropriately. So shout out to Tasha K. She's over on YouTube. Sounds like a great opinion here. I'm sure there's a lot more goodness there. And thanks to Julie Kelly for the hat tip on where that came from. So it's bedlam out there, my friends. It's absolute bedlam out there in the Fulton County District. Big Fani, Jocelyn Wade. We're going to have motions to unseal all these records, see what's inside. We're going to have maybe a deposition of Fani Willis, and it is going to be a lot of fun to unpack. And so, my friends, wherever it is you're watching this, thanks for subscribing to our channel. Thanks for sharing it with a friend or family member. Thanks for inviting them over to our live stream. Thanks for checking out robertgovea.com so that you can read all of these PDFs and more. As we're going through the show, you might want to dive into these PDFs. We upload them with the red lines so you can go through them. You can also sign up for our daily newsletter there so that we can email you all of the segments to your inbox. And that way, you can just forward those to everyone you've ever met. In your email contacts, send it to everyone. They love the forwards. Just keep it going nonstop. They'll thank you for it one day, and we'll appreciate it. So that, my friends, is going to be it for us on the day. We'll see you back here on the next one. All right, my friends. Now, that is it for us on the day. We covered some good ground. Look, Marvin is working away right here. Our friend Marvin, who helps us with the back-end editing, is there. He's on the mind map. You can navigate the mind map as well, my friends, by going to robertgovea.com. And so you can see Fani freaks out about this emergency motion, about this situation, filing an emergency motion, threatening her with criminal charges and smearing her name in the mud. It's about to get bloody. Then we've got Alina Habba, who is moving for a mistrial in the state of New York in the Trump litigation there. And Donald Trump, warning, things are going to be madness if this is not resolved appropriately at the Supreme Court. And I agree with him. That is not a threat. That is just how the country is going to fall apart if people like Crazy Eyes can go out there and just remove people from the ballots on their own accord. And so we're going to be covering all this, my friends. But now it's time to hear from you. And of course, as soon as we're done here, we're going to go over to watchingthewatchers.locals.com for our members only after party. And we would love to see you over there. We also do Saturday shows. We do member streams in the morning. And so come and check us out, watchingthewatchers.locals.com. Now, big welcomes to Knittin' Kitten, who is our first member on the day, becoming our newest supporter. Very nice to see you. Knittin' Kitten in the house. Show Bizzle's here. What's up, Show Bizzle? Says hello, everyone. Hello to you, Show Bizzle. It's a beautiful Friday. We've got this one from MAGA Hat Stays. Says, is it true E. Jean Carroll alleges Trump shouted, "This is MAGA country," while ravaging her in a public dressing room located next to the register in a crowded department store? Yeah, I think that was her testimony. She said, yeah, Trump grabbed her by the purse, shouted, "This is MAGA country," and then broke her clavicle on top of it. Good to see you, MAGA. We got this one from Christina. Hey, Noah and Waylon. Ultra shout outs, my friends. Guess who's joining us? Noah and Waylon are here hanging out with Aunt Christina. It's a beautiful Friday. Aunt Christina picked them up from school today. And so hopefully they're having a fun Friday. I'm sure it's a ton of fun. Noah, Waylon, hopefully you're having a beautiful Friday, my friends. And I hope you had a great day at school. And I hope you have a beautiful weekend. Thanks for watching our show here with us today. We've got Glocky McGlock is here. Says, this just happened a couple minutes ago. Remember when the smug sheriff said Trump will be treated just like everyone else? I wonder if her mugshot will be released. Oh, yeah, Fulton County. Look at this one from Glocky. Thanks for this. The Fulton County Commissioner requests Fani produce info on the alleged misuse of county funds. That's good stuff. Yeah, I mean, I'd like to know where, like if the dates match up. Was he billing for time while he was on a cruise? And how much time was he billing for while he was on a cruise? Like, what were the actual dates? Would be curious to see. Hey, what's up, Pinecone? A Father M is coming in. Father M, Captain S, Rick O, GL Satch is here. Charles S, all coming in courtesy of Pinecone 13, who's a membo, who's bringing in 5 new membos. Pinecone, thanks for doing that, my friend. Happy Friday to you. Glocky says, you know, they're going to audit the accounts of every DA in the office. And considering how corrupt Fulton County is, this could end up ensnaring the sheriff's department, a couple more DAs, maybe a judge or two. You know, Fani might turn state's witness to save her skin. Gosh, I don't know. Yeah, but there's definitely a lot going on over there. Patrick Parker's here, says, sorry, Robert, I already have a good VPN and hi. Well, that's okay. That's good. If anyone else needs a good VPN, that's the link's down in the description below. Good to see you, Patrick. We got Beamers here, says, I think Fani is just trying to deflect from the meetings at the White House. Well, the meetings at the White House are one thing. This is a whole different thing. Big time. This is a whole different thing. This is like criminality and conflict. It's bad. It's really bad. Glocky's here, says, oh, look, new toilet paper came in the mail. And look, you're watching the Watchers in the background, and guess what showed up in your mail? Nikki Haley for president. Says, I'm running. We know. We're not happy about it. Hopefully not for long. We got Glocky says, okay, so Democrats and Democrat courts think that they can kick someone running for federal office off the ballot, but also think states can't enforce their own borders using federal immigration laws, and they sue to stop them? How ironic. We've got this one from Brittany. Says, Rob, are you familiar with Bruce Rivers' Crim Lawyer Reacts? He did a vid about Alina getting, quote, tore apart by Trump judge. Couldn't even watch it all. Yeah, I'm familiar with him. You know, look, there are a lot of those other lawyer channels that grow very quickly. And if you look at them, well, you'll take a notice about how they're positioning themselves on Trump cases. All those other law channels that just explode, what position are they taking on the political topics? What does it look like? Not what we talk about here. Glocky says, he who has the podium shall have the power to rule them all. Well, that's what I thought. That's why that guy got arrested, because he took Nancy's podium. The lectern guy. Glocky McGlock is here, says, Knox is here. What's up, Knox? Says, TGIF, everyone. Coded messages. This is some of the dumbest stuff yet. Yeah, that's where we're at right now. Good to see you, Knox. Happy Friday. Hey, Marcia A says, Ray Epps is misdirection. It was all a setup. I think you're right about that. I think they wanted it to happen, and when it was happening, they enabled it to happen. Glocky says, can we all just admit it? Trump dressing up like Braveheart and leading an epic charge against the Capitol, it really would have been epic, and it would have guaranteed his reelection. Yeah, it looked like that blue war paint that Mel Gibson had. Freedom! You know? Like, oh, yeah, that's great. And definitely, that would definitely be more of an insurrection, sure. NY says, Congress ratifies the presidential election on J6. Colorado is usurping and subverting the Constitution by claiming the Secretary of State has a right to exclude anyone from the presidential ballot. What's up? Sandy's here. Says federal RICO, mail fraud, electronic fraud. In Wade's billing of 24 hours in one day, there's 2 predicate acts under 1961. The DA's office is a legit organization. It meets the enterprise requirement. Hired in 21, so 2 to 10 years, should seize Wade's bank account with taxpayer money. Yeah, that's one approach, Sandy. Sounds like you know your way around those statutes. You a prosecutor here? What's going on over there? But that sounds, yeah, maybe if somebody was interested in looking into it, they would. But they're pretty focused on Donald Trump right now. We got Tony Hay bringing in 10 new membos. What's up, Tony? Thanks for the bringing in of the membos. Keister Bunny's coming in. Fizbin G, Shaolin F, Jessa N, Tim F, Adam M, Nana Bright, Ernie C, Matt H, and our friend Just Cause coming into the house, courtesy of Tony Hay Munkets, bringing them in. Jackie Carrion, 9 months. That's the newest baby. We're celebrating newborn here. What's up, Jackie? I think he's going to be a soccer player. E. Carroll's lawyer is married to the judge's son. Look it up. So man, that's spicy. I definitely heard that one of the lawyers clerked for the judge. Is that right? Weird. I'm going to look that one up, Jackie. Thanks for that. Tony Hay says, her allegations came from an episode of Law & Order back in the mid-90s. Check it out. I've seen a clip on Doug in Exile. Oh, yeah, that's definitely there. Yeah, we have that clip, and it's true. Yeah, it sounds exactly like what they were talking about. Literally, even in a dressing room at Bergdorf's. Wild. Knox says, only a lover of close friends would know about the alleged adultery. It was not in the filing, and I doubt the dude tells everyone. It's pillow talk. Totally. Yeah, totally. And he's just trying to play it, you know. I'm sure he wasn't telling her about Fani. Aussie Kev says, Clinton and Schiff, they used the Russia collusion hoax for years to get Trump from the presidency. That's an insurrection. What Trump did wasn't even close. Oh my gosh, yeah, Russia collusion and many other things that are totally illegal. See my previous comment prior to your reading of the response. I'm going to keep going and see if I can make sense of that. Okay. Thank you, Knox. Knox sent that one in. I'll keep going. We've got this one from Rivka. Says Fani should indict Jocelyn, her attorneys, and the judge who signed off on the subpoena. Yeah, you're right. You know, we can't tolerate this bigotry from all of these people. It's very racist of them. Maybe they should go to jail for insurrection. Glocky says, can we just take a moment to reflect on how corrupt Fani is? Fulton County judges gives $500 fine, no jail time, to rioters who burned down an Atlanta Wendy's during BLM. Right? Yeah, different standards of justice for different sides of the political spectrum. NY says, take a bow, Rob. All the legal heads said it was master legal work to give Sidney Powell a diversion, as Trump will be the only defendant. There was no work on this RICO trial because it was fraudulent to fund their love tryst. You were right. Yeah, we could tell this case was just terrible, just from the legal work. Like, what are they doing over here? And when they came out, it's 4 diversions. They have 0 convictions here because they're not doing anything, because they're not that intelligent. They're on cruises. Air Force vet says he was billing for the drilling of the Willis who was willing. But he was billing for the drilling of the Willis who was willing. Oh gosh, that's true. That is true. Glocky says Clara Bowman is his mom. Oh, he brought mom on a cruise. Well, we love our moms. Moms are innocent, by the way. So Clara probably had no idea. She's like, I'm so happy for my son. He's got a great new job and this loving woman. And she's on money laundering Trump prosecution cruise money. Oh, gosh. Have whatever you want, Mom. Like, I love this. This is so great. Nice work, son. And just like Nifong and the Duke lacrosse case, I have a feeling that Fani will be whispering sweet nothings behind bars and forget. I don't think so. What are they going to do there? Even if they tried her in Georgia, they're not going to convict her. And forget about her bar card. She'll just say, white people and racism. And forget about her bar card. That will be taken from both of these corrupt lawyers. We'll see, man. I don't know. I feel like sometimes these people, like Fani got elected. Okay, a bunch of people were out there campaigning for her. You know, Fani's going to save us on Rachel Maddow. Yeah. Like, they know who she is. They know what kind of person she is, and they supported her anyways. Like, you get what you vote for, I guess. NY, good to see you. Clara Bowman is Wade's mother from Many-Wheat. Interesting. So he brought Mom. But did he bring Mom on the cruise? Because he only brought 2 tickets on that cruise, from what we saw. Wade purchased a ticket for his mother from her home in Houston to Miami with the same travel date. Yeah, Gloria B says, if Fani got married to Wade, pending divorce, wouldn't that give each of them immunity from testifying against each other if indicted for this farce? Well, like, let's say if Wade got indicted, then there would be some spousal immunity, some spousal privilege, and some marital immunity stuff that could come into it, so that she couldn't say certain things against him if he confided to her in it in the sanctity of the marriage. But they may not need her to testify, right? Like, this is just a financial crime. Good to see you, Gloria B. Stephen Mosher, what's up, Steve? Says, hopefully Congress will refer her to the DOJ. You know, the DOJ does nothing. 2025 RICO charges for Fani, Biden, Merrick, Jack Smith, all of them. I love it. We got this one from Scorpid Black Dragon, says, amen, Sister Tasha. Man, we love our brothers and sisters out there. And Tasha was on one. Man, she was on a tear. Love that. Air Force Vet says, another liberal bites the dust. Let the dominoes fall. I think, you know, this is a pretty big one. And this, yeah, it's going to be fun to watch this one unfold. Roy Boy, what's up, Roy Boy? Says, wouldn't the fact that Fani has so much information about the divorce indicate either pillow talk or she has illegal access to information from a sealed case? Yeah, I mean, that's really their point, is that it sounds like Fani was getting pretty intimate there with Nathan, given that she knows all about Jocelyn's alleged infidelities. Like, how does she know that? Does he tell everybody that at their office? Yeah, my wife cheated on me, man, in 2021 or whatever. 2017? No. He's telling that to Fani, so that Fani will make the Willis with Wade. What's up? We got Roy Boy. Dave says, I normally stay away from such celebrity gossip, innuendo, and titillating tales, but damn, these Fulton County shenanigans are a riot. I know, Dave. I honestly feel a little bit, like we would definitely not get into this, like in a normal case. Like if this is, what are the 2 people? Depp and Heard, like this type of stuff, like it's family law garbage. But she's a prosecutor and they're prosecuting Trump, so it's within our wheelhouse. And they use their Trump prosecution money to go on cruises. So it's like we can't. This is like all of the planets aligning here. Like we probably are never going to get a divorce case again on this channel. This one happens to involve Fani and a prosecution of historic proportions. It's like wild. We got Knox says, I mean, I wrote it before I heard it alleged. One thing I know, Robert, is men tell during special moments. Oh, Knox! Knox, sounds like you got some secrets over there, don't you? All right, we got this one from Sandy says, I'm a recovering sophisticated plaintiff in a protracted litigation resulting in a landmark decision involving RICO behavior before defendants resolved the dispute. Recovering sophisticated plaintiff in a protracted litigation resulting in a landmark decision involving RICO behavior before defendants resolve dispute. Winky face. From Sandy. Good to see you, Sandy. And thanks for bringing your expertise over here. How fun and how funny. Knox says, in fact, I thought they probably shagged in law school when she called him her old friend and mentor way back. We were on this case a while ago. Yeah, we were asking, like back then, I was like, old friend and mentor, who is this guy? He has no criminal law experience. I'm like, what's he doing prosecuting this national case? This is crazy. And so we just didn't hear anything about that. And then suddenly, lo and behold, boom, we've got a whole divorce saga already underway. And so, my friends, let's say hello to our friends on the X platform before we wrap it up on the day. Dolphin Fan is bringing in some new membos. What's up? Dolphin Fan is the man. Thank you, Dolphin. Bringing in HP, Holly P, Nunya Bitness, Narsos, Wrestler Town, and Donna O, all coming in courtesy of Dolphin Fan is the man in the house. Thank you, Dolphin, and welcome new membos. Let's say hello to our friends on X very quickly before we wrap it up and go on over to locals for our after party. We got 42 viewers, man, on X. 42 viewers. Shout out to our friends on X. Oh, here's a good one from Barb Loves Alaska. Says, here's a video of Fani. Promises not to date anyone that works under me. Ooh, that's going to be good. Thank you, Barbs. Dark Side Digital says, you know, Rob, in fairness, Lectern Leader did put it back after taking a few pictures with it. Well, he didn't want to steal the nuclear codes. He's a reasonable guy. I've seen his stuff. What's up? Oh gosh, we've got a Granny Cougars here. We got a Granny Cougars in the house. Says, I was going to write your name in leg on my magic marker. What is going on over here? Al Holman says, very nice work this week. Thank you, Al Holman. Stouffer says, okay, no Fanny's address. George is in the house. Raven Madness is over there. We see Kelsey's Critters. Good to see you. Patrick R. and our friends over on the X platform at Rob Govea ESQ is where you can find us. Before we wrap it up and head on over to locals for our members only after party, let's say thanks to our mods and our meme smiths who do amazing work keeping this show and all the things on track as we go throughout the week. Big thanks to Vienticus Prime, our friend K Bean, we got Just Cause, Playin' Hooky, Ronnie Cole, our friend Zulu, Beyond Geo, Zach Nichols, John Allen, Janek 909, our friend Dog Digger, and Donut Mind Me in the house. And so that, my friends, is it for us on the day. We are going to go over to watchingthewatchers.locals.com for our short after party, and then we'll of course be back tomorrow for our Saturday stream. YouTube friends, grab the Telegram link, members only Telegram link on YouTube in the community tab section on YouTube. And that's going to be it. We will be back here on Monday. And until then, I hope you friends have a tremendous weekend. I hope you get outside, get some fresh air, get some sunshine, get some vitamin D, get some good movement, spend some time with the people that you love, our friends, our family, all the people who enlighten and brighten our lives, because we've got to recharge our batteries, rejuvenate those energy tanks. We'll be back here on Monday to get into it all again. And we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful weekend, my friends. Sleep very well. I'll see you right back here on Monday. Bye-bye.